Senator Carney will be joining us. That makes it 10 now. And just let me know when we are up and running.
Up.
Okay, thank you. Good morning, all. Welcome to the Judiciary Committee meeting of March 23rd, 2022. Today we have 2 work sessions and a language review later on. We will start though with a freedom of access request, a freedom of access review. That will be the first item out of the gate. To begin, as we always do, I will begin with committee introductions, and I'm going to call on people as they appear in my panelist list, beginning with Representative Thorne.
Good morning, Mr. Chair. Welcome, everyone. My name is Jim Thorne. I represent House District 103, which are the towns of Herman, Carmel, and a portion of Etna up in beautiful Penobscot County.
Thank you, Representative. Representative Newell.
Yes, thank you, Mr. Chair. Good morning, everyone. My name is Raina Newell, and I represent the Passamaquoddy tribe.
Thank you. Representative Evangelos.
Thank you, Mr. Chair. I'm Jeffrey Evangelos, House District 91, and I reside in Friendship.
Thank you. Representative Sheehan.
Thank you, Mr. Chair, and welcome everyone. My name is Erin Sheehan, and I represent House District 12 in Biddeford.
Thank you. Representative Babbage.
Thank you and good morning. My name is Chris Babbage. I represent House District 8, which is most of the town of Kennebunk.
Thank you. Representative Libby.
Thank you, Mr. Chair. Good morning, everyone. My name is Laurel Libby, and I reside in Auburn and represent part of Auburn and all of my District 64.
Thank you. Representative Poirier.
Thank you, Mr. Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison. And I do have a couple of other commitments this morning, so I will be in and out a little bit, but I'll be here as much as possible.
Thank you very much. Representative Moriarty.
Thank you, Mr. Chair. Good morning, all. I am Steve Moriarty. I represent my hometown of Cumberland and part of Gray in House District 45.
Thank you. Senator Sanborn.
Thank you. I'm Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Thank you, Senator. Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is Northern Oxford County, in 2 communities in Androscoggin.
Thank you, Senator. And Senate Co-Chair, Senator Carney.
Good morning, everyone. I'm Ann Carney. I represent Senate District 29. That includes South Portland, Cape Elizabeth, where I reside, and a little bit of Scarborough.
Thank you, Senator. And my name is Tom Harnett. I serve as the House Chair. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside. And as always, we are joined by our analyst, Peggy Reinsch. Thank you, Peggy, for being here today and every day for that matter. And we are also joined by our committee clerk, Susan Panett, who keeps the show running behind the scenes. So the first item that we have on this morning's work list is a freedom of access review regarding LD 1822. We've been through a few of these this session, so this should be familiar to you all. We will hear from, after I turn it over to our analyst, we will hear from the representative of the Health Coverage Insurance and Financial Services Committee regarding their handling of LD 1822 and the creation of an exemption from the freedom of access laws regarding proprietary information. So Peggy, should I turn it to you in the first instance or?
Yeah, if I could just make a couple comments. One is, I hope you got the packet, and the back page is the chart. that we can work through with the questions. And also, I do send these out to the Right to Know Advisory Committee and give them an opportunity to weigh in with any concerns. And those have actually been helpful in the past because I share those with the committee who's sending it to you, and they sometimes have a much better response and are able to have a better discussion with you. I only got no concerns back in emails from members of the advisory committee. So I'd like to go ahead and I know that Representative Reckitt has joined since you started, but then Senator Sanborn can take it away.
Okay, well, I would give, before turning to Senator Sanborn, an opportunity for Representative Galgay Reckitt to introduce herself. You're muted, Lois, Representative Galgay Reckitt.
Whatever. Anyway, thanks so much. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland. I apologize that I'm looking off into the sunset, it appears, but it's only because my computer's a little screwed up. And so I'm actually looking at you, and that's my choice. So, so you'll have to look at the side of my face. So sorry about that.
Thank you, Representative Reckitt. And with that, I will turn it over to Senator Sanborn. And I don't know if you were going to present or you were going to have your analyst, however you want.
Our analyst, yeah, our analyst couldn't be here this morning. I don't think she had an appointment. So I'm just going to present as we've done in the past. So this is LD 1822. An act to improve access to behavioral health services by prohibiting cost sharing by insurers. It was amended in committee and we voted ought to pass unanimously. And it actually changed the title of the bill as well. And so the new title of the bill is an act to improve access to behavioral health services by limiting cost sharing by insurers. The relevant provision of the proposed committee amendment we are asking to be reviewed protects as confidential data reported by health insurance carriers to the Bureau of Insurance related to compliance with federal and state mental health parity laws. The language provides that reports made by carriers are public except for information that a carrier requests to be designated as confidential, and the superintendent of insurance is determined is proprietary information. Proprietary information is defined in the amendment as information that is a trade secret or business or financial information, the disclosure of which would impair the competitive position of a carrier or that would result in significant detriment to a carrier if the information were made available to the public. And so, as is typical, and when we come to you folks for review of these privacy exceptions, we've gone through each of the criteria and found as to criteria A and B that it's important for the Bureau of Insurance to have access to this information from health insurance carriers in order to determine whether carriers are complying with federal and state mental health parity laws. We're not aware of any particular federal law that applies to this insurer information. We don't think that paragraph D of the criteria is applicable. As to paragraph E, we believe that public disclosure of this information may affect a health insurance carrier's competitive position toward other carriers, and that these interests outweigh the public interest in full disclosure of the records. We believe that the health insurance carriers do have a relevant concern about the public disclosure of this information reported to the Bureau of Insurance because of the potential proprietary information or trade secret information to be included. We believe it is reasonable and appropriate for this information to be confidential as long as the superintendent of insurance has reviewed the information and determined it to be proprietary. Paragraphs F and G are not applicable as to... Sorry.
I am terribly sorry, Senator Sanborn. I was just notified that we are not online, and I want to make sure our chairs know as soon as possible. I checked and I can't find it. We're not live on YouTube for me to view either.
It says we are in the top corner of the screen.
Representative Libby.
It says that we are, but there's no video. It says that we're live though.
Okay, I will turn to our committee clerk, who's probably scurrying around right now and not looking forward for me to ask her questions. Soupy, if you can figure out what's going on and let us know what you learn. We'll wait until we hear from you.
Fortunately, I've just been reading from a piece of paper that others can read as well. So nothing too earth-shattering so far.
No, and I'll review that. Well, as part of the process, I pretty much review what you've gone over. So I'm not concerned about the lack of access, but I do want us to be online going forward.
Mr. Chair, do you want an update on the YouTube situation?
Yes, please.
Apparently there was a problem, and I've been told that those that don't get it, they need to refresh, and then you should be able to get it.
All right.
Representative
Thorne has it, so we're good.
Done so. So I will. The problem is those people who need to refresh aren't hearing what it is we're saying because they haven't refreshed yet. I don't know if it makes sense to send something out to interested parties, Soupy, or if you could just let folks know. And I'm getting my phone's sort of buzzing, and I'll see if it's about this.
I think that we're still broadcasting on the audio, right? And we are available on video. So maybe just a statement to folks who have tuned into the audio feed in lieu of the YouTube. Please refresh your YouTube and you should be able to see us.
Thanks. And I'm hearing from quite a few people that said they've been on, that we've been on the whole time. So
good.
So I will continue and hopefully people will be able to join us as they learn about the steps to take. And I would turn back to Senator Sanborn, and I believe you were just on paragraph G of our review sheet. If you want to continue, please.
Thanks. So we don't believe that paragraph G or paragraph G1 are applicable. Paragraph H asks about narrow tailoring, and we believe the language is crafted in this manner and that keeping this information confidential is appropriate. As noted above, the language provides the reports submitted by carriers are public, except for any information contained in the reports determined by the superintendent of insurance to be proprietary information. Further, the superintendent of insurance is directed to publicly report aggregate data from all carriers related to compliance with parity laws on an annual basis. And we did not have any further comments with regard to this privacy exception. And I would just note that the language that we're using in 1822 is model language that's been adopted in a number of other states, and all of those other states have also put in this proprietary information exemption in a similar format. So this is pretty standard. I'd be happy to answer any questions you might have.
Thank you very much, Senator Sanborn. Are there questions from committee members for Senator Sanborn? If so, please raise your electronic hand. And I am not seeing any, so thank you very much for your report on LD 1822. And thank you, Representative Libby, for letting us know that your constituent was back online. So I will now turn to our review, which will really just be a condensed version of what we heard from Senator Sanborn, and direct your attention to the final page of the material that circulated last night, which is pretty much our tally sheet, and I will run through the relevant paragraphs. With respect to paragraphs A and B, whether the record protected needs to be collected and the value to the agency, as we have heard, the Department of Insurance needs this information in order to determine that there is compliance with both federal and state laws regarding mental health parity. There is no federal law that requires this record to be confidential, so paragraph C does not apply. We then turn to paragraphs D through I, and we only need to find one paragraph that provides or that supports the exception, and that is paragraph E, which is whether public disclosure puts a business at a competitive disadvantage, and if so, whether the business's interest substantially outweighs the public interest in the disclosure of the records. As Senator Sanborn pointed out, this exemption is very limited. It only applies to material that meets the definition of proprietary information. And the statute sets up a two-step process. The first step is that the submitter of the information request that certain material that they believe to be proprietary remain confidential. And then the second step is that the superintendent of insurance or staff applies section 4C5 of the statute and determines that if the superintendent determines that it is proprietary information meeting the definition, which means information that is a trade secret or business or financial information, the disclosure of which would impair the competitive position of a carrier or that would result in significant detriment to a carrier if the information were made public. It is only after it is requested to be confidential and that determination is made that the material becomes confidential. And then the large question is whether the proposed exception is as narrowly tailored as possible. I believe that it is. The statute makes all information submitted as a public record except for carving out this limited exception for proprietary information. I would also point out, as I will on all of these freedom of access reviews, a change in our score sheet, and that is to remind you that records that have archival value that are transferred to the Maine State Archives for permanent retention lose their confidential status, even if they were deemed confidential after 75 years. I do not know if this material would be archival. Doesn't sound that way to me, but I am not the state archivist. So for those reasons, one, I'd be happy to answer any questions. I'd be happy to entertain a motion to approve the freedom, the request from the committee regarding LD 1822. Senator Carney.
Thank you, Chair Harnett. I move that the committee approve the proposed public records exception.
Thank you. We have a motion from Senator Carney. Do I have a second? Representative Moriarty?
I second it.
Thank you. We have a motion from Senator Carney, a second from Representative Moriarty. Is there any discussion from committee members? And not seeing any. Soupy, could you please call the roll?
I would be more than happy to, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kime.
Yes.
Senator Kime votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Representative Hagan. Representative Hagan is absent. Mr. Chair, I have 13 members of the committee voting yes, 0 in the negative, and 1 member is absent. That is the vote of the committee.
Thank you very much, Soupy. And with that, I will close the public records exception review of LD 1822. And I thank Senator Sanborn for her presentation on behalf of her other committee. Thank you, Senator. We will now open the work session on LD 2008, an act to establish a court process for involuntary substance use disorder treatment. And I want to see if the bill sponsor is in the attendee room, Representative Madigan, and she is. Soupy, could you please move over the bill sponsor to panelist status? Welcome back to the Judiciary Committee, Representative Madigan. It's nice to see you again. And I will begin by, we have a very thorough and lengthy bill analysis from Peggy, and I will ask her to give us an overview of that analysis. As I understand, we might be addressing an amendment to this LD.
Right.
So Peggy, please begin when you're comfortable.
Okay, thank you. LD 2008, an act to establish a court process for involuntary substance use disorder. It establishes a court process, as the title says, to allow a family, an authorized person who could be a family member, friend, or guardian of a person to initiate a process to basically end up in a court-ordered treatment for somebody with substance use disorder. And that could be inpatient treatment for up to 72 hours at a time. The total order of treatment could last for as many as 360 days. Leading up to that, once a petition is filed with the court, the person who is the subject of the petition is expected to go through an intervention. If the person agrees to accept treatment, they can then, the court process is canceled. If they don't agree to accept treatment at that point, they need to go through an examination with two different people that have two different professionals who can assess their substance use disorder. And all that information is provided to the court, and then the court can make a decision based on clear and convincing evidence. So if the court has good cause to believe that the treatment for the respondent is warranted, the court sets a hearing for 14 days. That can be an ex parte hearing at the beginning. The hearing that's held within 14 days is a full hearing where the person appears, and that's where the court decides by clear and convincing evidence, specific criteria that's in the statute, including that there's imminent danger to self or others, and that the respondent could reasonably benefit from treatment. My understanding is that this could happen if the respondent, the person who's subject to this order, needs the involuntary treatment that can be renewed as time goes by. The bill also says that all the rights applicable to persons subject to involuntary hospitalization apply to the respondent, and it requires a review by the court, a regular review by the court. Current law defines mentally ill person for the purposes of involuntary commitment to include persons suffering effects from the use of drugs, narcotics, hallucinogens, or intoxicants, including alcohol. So there really is some ability right now to pull somebody into the involuntary commitment process if they are suffering the effects of the use of drugs, including alcohol. You heard a whole lot of testimony, and I know that there was discussion about the Kentucky law that this is based on, Casey's law. My understanding is there are some constitutional challenges filed, but those records are sealed, so we don't know what's happening with the case or even who the plaintiffs are, although they are being represented by the Public Advocacy Department, which is their public defenders in Kentucky. So there are some constitutional rights raised by this. There's the rights of due process because of a deprivation of liberty. what's the appropriate standard of proof. This includes clear and convincing evidence, which is definitely better than preponderance, which I believe is the standard in Kentucky. There's also a person's right to consent or not consent to treatment, the right of privacy of medical and mental health records. This does provide for the assistance of counsel, and we assume that would be MCILS would be providing those. So there would be, you'd want to look at when is an attorney pulled into that situation. And kind of the one of the biggest questions is who is treatment available when you have somebody who needs it, and is the court process orders that this needs to happen, is treatment available. There's a question about who pays for the treatment. In Kentucky, the law directs that the petitioner has to execute a bond to provide for the treatment, and lack of capacity for the district court to take on additional cases was identified by the judicial branch. We don't have fiscal impact for the bill, but I know that Representative Madigan is proposing an amendment, and she's here and can speak to that, I'm sure, if you're ready for that. But I'm happy to answer any questions about the bill.
Thank you very much, Peggy. Before turning it over to the bill sponsor, Representative Madigan, are there questions for Peggy regarding the bill analysis? If so, please raise your electronic hand. And Representative Thorne.
Thank you, Mr. Chair. I just want to make sure I heard you right, Peggy, when you said there is no fiscal note and there's no determination yet as to who would be liable for the cost of the treatment. Is that correct?
Well, there's no fiscal note yet. They haven't been able to do the analysis yet. So we don't know what that is. We have no information yet, but you're right. There's nothing in there that says who pays for the treatment. And as I mentioned, Kentucky requires the petitioner to basically provide some kind of surety that they would be able to pay for whatever treatment is ordered. I don't know if that actually happens. That's in the statute, but right. So that is a question that was raised, is who would be paying for this treatment if it's ordered by the court.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. Representative Moriarty.
Thank you, Mr. Chair. Peggy, you mentioned current law providing a process for involuntary hospitalization. Does that apply to those who suffer from substance abuse disorder as well as other conditions?
Well, if they meet this definition, and I'm not sure how this applies. So a mentally ill person is the terminology. And it includes persons suffering effects from the use of drugs, narcotics, hallucinogens, or intoxicants, including alcohol. So that doesn't, I mean, this was written before we actually had the terminology substance use disorder. I don't know that if this were written now, we would actually write that term in there. I think if you look at compilations of states and how they deal with substance use disorder and involuntary treatment, Maine is actually listed as one of the states that has the opportunity for involuntary commitment for substance use disorder. And they're using, I'm assuming they're using this definition of mentally ill person that includes that.
And as a quick follow-up, do you know if the current law provides a similar sort of ex parte procedure and consultation from experts in the area before a judge makes a final order?
Well, I think we've talked about the involuntary commitment for somebody who is mentally ill. When the law enforcement officer brings them to the emergency room and they're examined, the law enforcement officer believes that there is, they have probable cause to believe that they are mentally ill and they exhibit either imminent danger to themselves or to others, or they're unable to assess the risk of their situation. And that brings them into the whole assessment process of where they are assessed. That's a blue paper. So that's how they get into the process. And so if they meet those criteria of being imminent danger to themselves or others because of their substance use disorder, I'm assuming they can be brought into under the current system. That might not be the type of treatment that is necessarily appropriate for the person, because that's more geared at mental health issues. And so I'm not sure what happens at that point using the current system, but I will say that Maine is listed as one of the states that has this as an option for involuntary treatment.
Sure. Thank you, Don.
Thank you, Representative, and thank you, Peggy, for your response. And I am not seeing any more questions from committee members. So I would like to welcome Representative Madigan. I understand that you have an amendment to LD 2008, and I'd like to provide you with the opportunity to explain that to the committee.
Sure. Thank you very much. Good morning. After being in the public hearing and hearing both the departments and Jeff Austin from the Maine Hospital Association, and now even further hearing this analysis that the current law does not prohibit the use of the involuntary hospitalization process for substance use disorder treatment, I propose an amendment that creates a legislative study committee. Although many people seem to feel that the current law allows for this, in practice, it's not happened. I would say that, and that as I'm saying that as someone who's been a social worker for many years and whose job as a crisis worker required me to actually do the blue paper process with people. And in practice, in hospitals and among crisis programs, that's always a disqualifier, that you don't see those folks and you don't do that process with them. So I think clearly part of this is a practice issue. And so I think getting folks together to figure out what would be helpful and to clarify that would be helpful. The other thing I would say is that the difference between this legislative committee and others is in the amendment, I put that the committee can report back for a bill to both the Judiciary Committee and the Health and Human Services Committee, because I think if it's a practice issue having to do with medical education or program, then that should go towards Health and Human Services Committee and not to Judiciary. The other thing I would say about this is that I think, as I said in my testimony, substance use disorders are considered a behavioral health disorder. They're listed in the same book of that. I was specifically trying to get at co-occurring disorders, which is one of the barriers I see happening now, which is for folks who have co-occurring physical or mental health diagnoses along with substance use disorder. If their primary presentation in an emergency room is SUD, then they're not getting access to treatment. And that, I think, is a huge problem. It's costing lives, obviously my sister's. And I would remind folks that we highly leverage treatment in a lot of other ways. If you have an OUI and you want to get your license back, you have to go through a process where you have a substance use disorder evaluation and follow through with any treatment recommendations. If you are involved with Child Protective Services and a substance use disorder is identified, you are highly leveraged into treatment in order to retain or regain custody of your children. And so I think that even some of the evidence that people have presented that it's ineffective, I think we need to also include evidence and discuss evidence around highly leveraged programs and how highly leveraged treatment works. So would be happy to take any suggestions, any questions on the amendment, which I hope that we can dig deep into this. And I would remind folks that a lot of the national data indicates now that in fact, there was a really good piece in the New York Times just 2 days ago about the increase in alcohol-related deaths, including due to withdrawal. So I think this is an issue we have to get our heads around. Thank you.
Thank you very much, Representative Madigan. Are there questions from committee members for the bill sponsor? Representative Moriarty.
Thank you, Mr. Chair. Good morning, Representative Madigan. I'm looking at section 7 of your proposed amendment, which establishes the deadline for the report of the commission, but I don't actually see who they report to. And you just referred to both Judiciary and Health and Human Services. Perhaps I've overlooked something, but.
Oh, I actually talked to the Opal analyst about that. She said it was unusual. I'm sorry if it's not in there, but that was my suggestion, that report back to both committees.
So it should be in there.
Yes.
I see. Okay. And as a follow-up, are you, I take it you must be comfortable with an all legislator committee as
Nope.
opposed, oh,
I'm sorry, Representative Moriarty is looking at a different draft.
Okay.
it came out yesterday.
There were two.
Is there something
Is
newer
that
than
what I
that?
sent to you?
7:31 p.m.
Maybe before we do questions, if Peggy could screen share the most recent draft, because I think I have the same one that
I
Representative.
must have
Moriarty
sent
does.
the old draft. I'm sorry that I had kind of been doing as a spec draft. Okay.
I'm sorry. I'm
No,
sorry
it's
too.
totally my fault. I really, I apologize. I can share this draft online and I can email it to you. Wow. Let me email it just real quick. So for those of you who like it that way. Okay, not showing up. I will email it as soon as we're done talking about this.
I will say that it wasn't an entirely legislator committee. It included folks representing hospitals, SUD treatment providers, people, a person with lived experience, a person representing families impacted by substance use disorder. So I tried to, someone representing kind of emergency room providers, since I think that's a place where lots of these barriers and bottlenecks may occur. So.
Thank you, Representative Madigan. So Peggy, it would be great if you could walk us through.
Oh, okay, great. So
committee
this
names
consists
and
of, my apologies for sending that the wrong draft. So this is 13 members, 3 members of the Senate, 3 members of the House of Representatives, 1 member appointed by the governor, 1 member representing hospitals, 1 member representing substance use disorder treatment providers, 1 member representing families affected by substance use disorder, 1 member with lived experience with substance use disorder, 1 member representing primary healthcare providers, and 1 member representing emergency room providers. And they can, of course, pull other people in to provide them information. This is pretty boilerplate about the appointments, and then the duties would be to review services and processes currently available in the state for persons with substance use disorder, review options offered in other jurisdictions, including but not limited to judicial orders for involuntary treatment, as well as other highly leveraged treatment options, and review the outcomes, review the constitutional and other rights of persons with substance use disorder and how jurisdictions protect those rights, and then develop recommendations, including implementation plans. And then here's that the study group would report to both the Joint Standing Committee on Health and Human Services and the Joint Standing Committee on Judiciary for presentation to the 131st legislature. So I'm going to stop sharing so you can talk, and I will find the correct one to send to you.
Thank you. And I have a question for Representative Madigan. Given that one of the charges to the committee, and I'm reading from the old version, but I think it's still in there, is review the constitutional and other rights of persons with substance abuse disorder and how other jurisdictions protect those rights. That's still in there, Peggy?
Yes.
Was there consideration given, and I don't have the list in front of me, but to having someone representing a civil liberties organization on the committee?
I thought about that. My only question was, since it's 13 people, I mean, we can add a 14th if you think that would work and add someone in for that. I think that would be fine. The usual kind of standard amount for these committees was 13, but I would be fine with adding in that. I had considered it. I was toying between that and the emergency room providers.
I personally, I see the need for both, and I think that a lot of the testimony that we heard raising concerns about the original bill was from those organizations. So I would ask if you would accept, well, if it gets to a motion, a friendly amendment to add that. 14th.
I would accept that. I would accept that, absolutely.
Okay, thank you. Are there questions for our analyst or Representative Madigan? Representative Poirier.
Thank you, Mr. Chair. Representative Madigan, I was just curious if you actually spoke with or collaborated with any of the recovery advocacy programs, organizations, perhaps Courtney Allen or anybody when you created the amendment?
Actually, I initially talked with Courtney Allen about this back in November. And then in January, after my sister died, I reached out to her a number of times, but did not hear back from her until the day before the public hearing. What I would say is that she had offered up an amendment. She had said a study committee in her public testimony. And I actually heard that feedback from both the hospitals and from her and recovery advocates, and that's why I came up with this amendment. But I did not talk to her directly about this amendment, but I think it's important that recovery advocates be involved in the study makeup.
Awesome. Thank you.
Thank you, Representative Poirier, and thank you for your response, Representative Madigan. Are there additional questions from committee members? Senator Carney.
I was just curious if Representative Moriarty had his questions addressed. It looks like he has.
Oh, I did not see his hand up. I apologize.
I think I'm okay so far. I'll let the hearing proceed.
Thank you.
I do want to add, just because I think Representative Moriarty's question before you guys were talking about the Kentucky law, I want you to remember that Casey's law was originally passed in 2004, and that was before the Affordable Care Act and before Medicaid expansion. So that was a big fight in Kentucky at the time. But since that time, we've had the Affordable Care Act and Medicaid expansion, including in Kentucky. So some of the issues around the surety bond and things like that have not been an issue of late for the past 10 years or so.
Okay.
Thank you. Did you have an additional question, Representative Moriarty?
Mr. Chair, could you just restate your description of the additional person you would add to the committee?
A person representing an organization that deals with civil liberty interests.
Okay.
Or whatever the magic words are that we use.
Right.
That category.
Do you see a need for a specialist in constitutional law, that is to say a professor who deals with the constitutional implications of statutes of this type?
That was not the intent of my amendment. I didn't want to make it that specific, but I do see other hands up. Senator Sanborn.
Representative Moriarty, I think that is an appropriate person for the committee to hear from as an invited guest, but it isn't necessary to have every source of information also be on the committee itself. So I think a professor would be an appropriate session to have where folks got that information. And perhaps more than one professor might have different opinions.
Thank you. And Representative Galgay-Breckett, I apologize, your electronic hand was up and I overlooked it.
Thanks. My question's on a slightly different angle, so it's just as well that Heather went before me. My curiosity is, and my brain rises and falls and dies and wakes up on the issue of study committees. Is there not a limit on how many there can be? Is there not a limited budget for them? Somebody want to remind me what those rules are? Probably Peggy, but go ahead.
I would turn to Peggy, and my understanding is if it's over 13, we have to make a request, but I know Peggy doesn't go on what she thinks, goes on what she knows.
Well, right, Joint Rule 353 addresses legislative study commissions. They need to be reviewed by the Legislative Council. There is a fund set aside every year to fund studies. It's not a whole lot of money. Studies, if you're not paying for anything other than travel and expenses of legislators that are on it, are not incredibly expensive. So that's not usually an issue, but there is a staff capacity, and whether it meets the Joint Rule 353 requirements, which is a maximum of 13, and the council can okay going more than 13. Everything has to be reviewed by the Legislative Council if it's a study committee that has anything that has legislators on it, or is staffed by legislative staff. So all of those will go before the council, and they kind of decide. It's almost like priorities on the appropriations table. If you have more than one study that you want to support, then the committee should probably send a priority memo to the Legislative Council as well. Did that answer your question?
90% of it.
Okay.
Does anyone have an idea of how many gazillion studies have been recommended this session or will be? I have no concept. And you may not either, because you staff a particular committee and may,
Right. I think there are quite a few that are being proposed. I'm not sure if they're in their final stages yet. So what usually happens if the legislature approves it, it's almost like the appropriations table. There's a study table. So if it's a resolve, it'll be finally passed in the House and go through its readings in the Senate. And before final passage, it goes to the study table. And that's when the Legislative Council makes its decision once it has most of them there and knows what's coming.
All right, thank you. That's very helpful to remind me of all that, which had slipped from my brain. Thank you so much.
Thank you, Representative. Representative Records, do you have an additional? Thank you. Are there additional questions from committee members? Seeing none, is there anybody who is interested in making a motion? Senator Carney. I'm seeing hands go up and down. Representative Libby.
Thank you, Mr. Chair. I wanted to start off the conversation. I do have a motion, but I want to explain it first. In my career at the bedside as a nurse, there was literally not a single shift that I worked where I would pick up a patient in the ER to bring them up to the ICU where there weren't the ER hallways lined with patients waiting for beds for mental health treatment and substance use disorder treatment. We have had a shortage of beds for
this minute, Peter.
As long as I can possibly remember. And so I think of that as we look at this bill. I'm sorry, I'm hearing background. Sorry, easily distracted. And I'm very sympathetic to the loss that the sponsor of this bill has suffered, our family having suffered similar loss. But I do want to ensure that we are cognizant of the substantial challenges that this bill brings as far as individual liberties and constitutional concerns, the potential to criminally punish people with substance use disorder, and some of the other challenges that we heard about in the public hearing. And so in thinking about all of that and thinking how terrible the lack of access to substance use treatment, and that there's not even enough at this point for those who want such treatment, and that we lack even the professionals to follow the protocol set forward in this bill. I would propose sending a letter to the Appropriations Committee. I don't know if a study will be funded or not, but I would like to send a letter to the Appropriations Committee. Unanimously, it would be amazing, asking them to prioritize the bills that are currently sitting on their table that would appropriate funds that would help with the lack of staffing professionals that we have in the mental health and substance use treatment area, so that hopefully we could make a difference in that area and begin to actually be able to treat these patients adequately and provide beds where there are none at this point. So I would move ought not to pass and send a letter to the appropriations table from our committee asking just that, funding current bills and initiatives that are on the table, simply waiting for funding. We have the surplus to do it. And we should fund our mental health and substance use disorder professionals adequately and encourage them to work in our state.
Thank you, Representative Libby. And just so I am clear, your motion is ought not to pass with an addition of a letter coming from this committee. Do you see those as two separate things, or do you want that to be in the same?
I mean, I see it as the same, but if it needs to be separate for protocol, then that's fine. But they are very much tied together.
I understand that. I think that we need a motion on the bill that is before us. So I'm going to stop with the ought not to pass on.
Yep.
Okay.
Thank you.
Thank you, Representative Libby. We have an ought not to pass motion. Is there a second? Senator Keim?
Thank you. I will second the motion. I just wanted to add in that this is the second, well, we've heard a lot of bills that actually have touched on the fact that there's not enough providers in the state of Maine, and there's really dire consequences for it. And we just recently voted ought not to pass on Senator Timberlake's bill, which was, equally as heartbreaking. And it knowing that we need to do something, but the bill he presented wasn't the thing that, wasn't a thing we could do. But, I think in light of both of these bills, a letter from us is so appropriate. So I second the motion ought not to pass, but, looping in as well the idea that our ought not to pass on this bill and the other bill, Senator Timberlake's bill, just doesn't do justice to what we've heard for the problems in the state.
Thank you. We have a motion, an ought not to pass motion by Representative Libby, seconded by Senator Keim. I'm going to open it up to discussion. I will begin with Senator Sanborn.
Thank you, Mr. Chair. I guess I would hope that my colleagues would agree, because I think it's absolutely true that making the funding of rate increases a priority and finding other ways to eliminate wait lists and fund mental health treatment and substance use disorder treatment is a shared priority. And I think bringing that to the Appropriations Committee with a unified voice is absolutely something that I agree with. It's the ought not to pass part of it that I think I would like to discuss more with my colleagues, because I think that the question of the question of how to approach involuntary admission for substance use treatment is something that the recovery community, I think, is wrestling with internally. The tension between harm reduction and the ability to get your loved ones the treatment that they need, kind of even when they don't know that they need it. The intersection between co-occurring disorders, folks who struggle with schizophrenia or bipolar disorder and substance use, which is extremely common, and whether that ends up costing them their lives because they can't get the treatment for the bipolar disorder because they also have substance use disorder, and that sort of ends up disqualifying them from these involuntary commitment proceedings. I think all of those issues are really important, and they're not funding issues. They are policy issues that I think it would be really helpful for us to convene a group to look at seriously. We know that overdose deaths are on the rise. In Maine, the numbers are terrifying, just 3 months into this year. And so I think that devoting resources to study this particular issue, and as Peggy noted, it's a relatively small amount of resources to get a better handle on it. And then to take up whatever those recommendations are, whether they're recommendations in the HHS arena, whether there's recommendations that come back to this committee next year. And they may look like this bill, or they may look very different from this bill, frankly. But I think that having serious people convene to talk about those policy pieces is very worthy of our unanimous support as well. And I understand the reticence about study groups, but if ever there was a group of individuals who are truly committed to working on this issue, we heard from them in the public hearing on both sides of this bill that Representative Madigan brought to us. So I really hope that my colleagues might support a letter as described by Representative Libby and an ought to pass as amended motion, turning this into a resolution for a study. So I'll leave it there, but I think this could be an area of bipartisan collaboration for our committee, and I hope that it will.
Thank you, Senator Sanborn. Senator Carney.
Thank you, Chair Harnett. I agree with the statements of Senator Sanborn, and I wanted to add that there are a lot of really important funding proposals on the appropriations table that relate to substance use disorder and mental health care. But what we haven't seen is a policy focus on how to address this one really pressing issue of how to get people the treatment they need. And my heart goes out to Representative Madigan. She has really put her family's tragedy front and center to help us understand how complicated these policies are. And I think it's really important to take the next step and really figure out what the policy solutions are. And then that I think that by determining what the right policy solutions are, we can spend the state's money in a really effective and efficient way. Right now, we don't know exactly the best way to address this pressing situation. So I'll be voting against the pending motion and supporting an ought to pass motion together with the letter that Representative Libby suggested.
Thank you, Senator Carney. Representative Sheehan.
Thanks, Mr. Chair. And I don't want to be repetitive. I do agree with Senators Carney and Sanborn in that I'll be voting against the pending motion, but I just wanted to mention some of the reasons for that. You know, in her discussion of her proposed amendment this morning, Representative Madigan brought up some really sort of granular practice issues, and I was particularly alarmed to learn that in practice, the work that our committee has done around involuntary hospitalization is not being consistently applied, and that practitioners are being presented with some serious obstacles in getting folks help. I think that is a separate issue from the issues of funding, and I just think it's really important for this study group to convene and have this conversation. I'm hard pressed to think of an issue that is more important right now in our state to so many families in Maine. So I will be voting against the motion that's on the table, but also supporting an ought to pass as amended motion that includes a letter to appropriations.
Representative Moriarty. You're muted, Representative.
I think I was muted en masse there. Following last week's public hearing on the bill itself, I had some serious concerns about its practicable application or effect, in that we had testimony from the Judicial Department to the effect that the district court simply didn't have the capacity to take on a new book of business of this type. And secondly, that there currently were not sufficient beds or providers to take care of those who willingly and voluntarily are seeking help. That would have made it a difficult call for me on the underlying bill. The replacement bill, which is now a resolve, I see as a step in the right direction, and we set aside for the moment, so to speak, how the courts may absorb this new workload if in fact it is determined that a new type of procedure is needed above and beyond that which is already contained in law. So on balance, I will vote in opposition to the motion. I support a letter to AFA and would suggest that perhaps there is some way of with all the different substance abuse matters pending before them, if there's a way of charging this committee with broader responsibility, so we don't have competing committees or bills without adequate foundation. Thank you.
Thank you, Representative Moriarty. Representative Thorne.
Thank you, Mr. Chair. And I hope I was able to keep a straight face when Senator Sanborn mentioned bipartisan support. But on the issue of substance abuse and how many different varieties of substances that covers, and the word involuntary into counseling and so forth, it's hard for me to wrap my head around it. And I also think about what this does for other things in society that people are trying to help people. I too had a family member, late family brother, that succumbed to the same type of issues. And we tried to get him into, and he was involved in substance abuse counseling most of his adult life. The issue wasn't getting him in counseling. So I find it difficult to say that if somebody has a bad night or somebody does something at a party and it involves a trip to the hospital, that they're going to be automatically enrolled involuntarily into a substance abuse program. So I think this net would catch a lot of fish that aren't intended. What precipitated this bill with Representative Madigan is tragic, but to be able to capture everybody in that net, I think is going to be even more tragic than just helping the ones that need it. So I will be voting in support of the motion and recommending the letter as well. Thank you, Mr. Chair.
Thank you, Representative Thorne. Representative Galgay-Reckett. Representative Reckett, I cannot hear you.
Okay, sorry. I'm really glad that Representative Libby brought up the substance of the letter to appropriations. And frankly, I think it ought to be dumped on the desk of HHS at the same time. But what I want to make sure happens is that whether we do an ought not to pass or an ought to pass, I think we're in pretty collected belief that such a letter ought to be sent, whether or not we pass or don't pass this bill. But I think that for me, it's important that, and this is, the people in my life that have been lost are not my own personal relatives, but my wife's relatives, a couple of whom we've lost to suicide. Two of them were the victims in the case that Senator Timberlake's bill addressed. So it's important to me that we try to find a way to at least articulate the connection between both Representative Madigan's situation and Senator Timberlake's. I know they're not the same. I know that there are law enforcement issues in Senator Timberlake's issue, but I think that somehow if we can craft into the words of that letter some acknowledgement that we understand that both of these situations need looking into. Not necessarily in this particular study commission because it really seems quite separate. But I think that it's important that we do as much as we can. So I'm intending to unfortunately vote against Representative Libby's motion and support of ought to pass motion on this resolve. But I want to make sure that, as some others have said, we don't lose the concept that is so important, I think, of Representative Libby's proposal.
Thank you, Representative. I do not see any other hands up, but and I do want to speak, but I don't want to speak if there are other committee members who wish to weigh in at this point. So with that, first of all, I want to separate the letter from the motion. The motion we have on the table is ought not to pass. I fully endorse Representative Libby's suggestion about the letter, but I see it as a separate matter. I will be voting against the ought not to pass motion for a couple of reasons. One, speaking for just myself, the public hearing on this bill was the single most difficult hearing I've sat through in this body. I admire and respect the bill sponsor, Representative Madigan, for bringing it forward, knowing how difficult and personal this issue was and is to her. I also respect and appreciate her recognition of some of the problems and issues that were raised by persons opposed to the bill, and her willingness to step back a bit and say, okay, we need to look at these issues and we need to bring a wide variety of stakeholders and interest groups to the table. And I thought that was the right decision. So I will be voting against the ought not to pass motion, supporting an ought to pass as amended report. I'll wait to hear what those reports are before signing on. And then would like the committee to address the separate issue about communicating our concerns about a variety of bills that we've dealt with this year, as expressed by Representative Libby. So how I made it clear, I'll be voting against the ought not to pass motion. And I do not see any other hands up, so I do see a hand up. Senator Carney.
Thank you. I've been struggling with whether to speak or not, and I did want to speak just very briefly, and particularly to you, Representative Thorne, because I think what I heard from you was that we both have brothers who passed away as a result of substance use disorder, perhaps in a similar way to Representative Madigan's sister. And I hear you and have the same reaction that you have when you raise the concern about somebody being kind of swept up in this involuntary commitment without any attention to the particular individual and circumstances. And I think that the amendment, the study, does help us work through that issue of how do we get treatment to the people like both of our brothers who needed that treatment. And that's why I'm supporting the study aspect of the proposal that is before us. And I just wanted to reach out to you as a concerned sibling, a heartbroken sibling to a heartbroken sibling. And I'm sorry for your loss.
Thank you, Senator Carney. Seeing no other hands, Supi, if you could call the roll on the ought not to pass motion.
I would be happy to, Mr. Chair. Senator Carney.
No.
Senator Carney votes no. Senator Sanborn.
No.
Senator Sanborn votes no. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
No.
Representative Harnett votes no. Representative Babbage.
No.
Representative Babbage votes no. Representative Galgay-Reckitt.
No.
Representative Galgay-Reckitt votes no. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
No.
Representative Sheehan votes no. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
Yes.
Representative Libby votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell.
No.
Representative Newell votes no. I will recall the absentees. Representative Hagan. Representative Hagan is absent. Mr. Chair, I have 3 members voting in the affirmative, 10 members voting in the negative, and 1 member is absent. That is the vote of the committee.
Thank you, Supi. And for those voting no, I'm going to make a suggestion. My report would be ought to pass as amended. The amendment being the proposal that we received today from the bill sponsor, with the addition of a representative of an organization representing civil liberties and constitutional rights. Is that acceptable to, is there any person who voted no that is not acceptable to? Representative Evangelos?
I was going to second it.
I don't think we need to second it. I think it's just a minority report, right? I mean, Supi?
For my purposes, I understand what you need, but I'm almost, for the record, I'll go to Peggy on this one, because you have a, I would think it would be cleaner if you did a brand new motion and then vote, we could revote that.
Okay.
You end up having a motion that passes.
Thank you. Then I would entertain a motion and recognize Senator Carney. I'm sorry, actually, Representative Evangelos, you had your hand up first. Would you go ahead?
I'll defer to Senator Carney. I was just going to second it. Go ahead, Senator Carney.
I'm having a hard time speaking, but I'll just move the report described by Representative Harnett.
I'll second it as amended.
Thank you. Is there any discussion on the motion? Seeing none. Soupy, thank you for getting me on the straight and narrow. Could you please call the roll?
I would be happy to, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kime.
Yes.
Senator Kime votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Libby.
No.
Representative Libby votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Representative Hagan. Representative Hagan is absent. Mr. Chair, I have 11 members voting in the affirmative, 2 members voting in the negative, and 1 member is absent. That is the vote of the committee.
Thank you very much, Soupy. Representative Madigan?
I would just like to thank everyone. And I recognize that this is a very difficult and complex issue, particularly if you don't work in it, as well as experienced it like I have. I've already started conversations with the hospitals about practice issues. And I think the public hearing brought forward a lot of people who definitely want to solve that. So I look forward to a study committee actually addressing this. And I would also add that for those of you with concerns about this, the problem of addressing co-occurring disorders and the barriers I think that were identified predated the current shortage of beds. And this is an issue that is long going and actually is kind of a struggle that's been going on for 35 years for what do we do for folks who have both medical and psychiatric issues in addition to substance use disorder. So thank you very much.
Thank you very much, Representative Madigan, and thank you for bringing this bill forward.
Thank you.
Committee members, I'm going to see what Soupy has her hand up for, and then I have a request and recommendation. Soupy?
Mr. Chair, for the record, could we have what the minority report is, please?
Thank you very much. For those members who voted no, was it straight ought not to pass?
It is an ought not to pass, but I do want to clarify that I still support the letter and look forward to ensuring that that gets to appropriations. And I'm certainly not averse to HHS as well.
I do, and I thank you for that, and we will discuss that. But at this point, and I am speaking again for myself, but I'm not sure if I'm alone. I would like a 10-minute recess, and we will reconvene at 11:40. So do I need a motion for that, Peggy?
No.
We're in recess until 11:40. Thank you. Please shut off your mics and video. Hello, committee members. It's 11:40. As soon as you are back, please turn on your cameras so I know that we have a committee. And I know it may take a couple of minutes for people. So just as you're back, and I'll make this reminder every minute or so, or they're knowing me probably every 15 seconds or so, just turn on your cameras when you're back. Again, committee members, if you're back, please turn on your cameras so I know that you're here.
Mr. Chair, I am here, but I'm just going to be off camera for a few minutes finishing up my morning snack.
Oh, okay. Why don't you have that snack? Because I'm going to be calling on you in a bit. So we'll wait for you to snack up. Okay, it looks like we are back for the most part. Welcome back to the meeting of the Judiciary Committee. We did just vote on LD 2008, but I wanted to get back to the suggestion made by Representative Libby regarding a letter from the committee to AFA and perhaps HHS about the plethora of bills that we've dealt with this year in different fashions that have really educated the committee about serious problems with the availability of mental health treatment, payment for workers professionals who provide that treatment. And I would like Representative Libby to restate what she would like to see in the contents of that letter, and then I hope what I think is a path forward. So Representative Libby, again, thank you for raising that issue, and if you could just sort of restate so Peggy knows where we're going.
Thank you, Mr. Chair. I simply would like to send a letter to appropriations, and if the committee are in agreement, I'd be happy for it to go to HHS as well to prioritize existing initiatives. And I don't have in front of me all that are currently sitting on the appropriations table. I'm sure that if we chatted with our colleagues in HHS, we could get a better idea of some of those, but particularly a focus on bills that address compensation for mental health care providers and those dealing with substance abuse treatment.
Thank you very much, Representative Libby. And Peggy, does that give you enough guidance? Thank you. And with that, I want to ask, are there any committee members opposed to doing this? Because what I would suggest is to have Peggy draft the letter, circulate it to all committee members, and then we can indicate whether we want to sign on or not. I can indicate right now that I will want to sign on, but I'm not making that decision for everyone. I just want to create the most efficient process possible. We don't need a motion on this. So unless I hear an objection, that's how we're going to proceed. So with that, if you say, no, that's not how I want to go, just raise your electronic hand and let me know.
Okay.
And I am not seeing any electronic hands. So again, Representative Libby, thank you very much for the suggestion, and Senator Keim as well. And I would hope that we see a letter and can provide a unanimous statement on these issues. So thank you. And with that, I will now turn the electronic gavel over to my co-chair, Senator Carney.
Thank you very much, committee members. And so now we'll turn to the next bill on our agenda today, and that is LD 2023. It's a very long name, including a word that none of us can remember how to say, but it is an act to implement recommendations of the Secretary of State regarding notarial acts, which I hope I pronounced properly. And I think, Peggy, we had done the major part of the bill analysis, and you had some suggested amendments. I'll turn the floor over to you.
Okay, I know that there were some outstanding questions and some things that I said, oh, we will look at that in more detail later, but why don't I just show you I think I sent the proposed amendment, and hopefully I sent you the right one last night. But here's, I'll share my screen just real quickly about the things I had raised, and then one issue the Secretary of State had added to this amendment. I'm not saying that you're done with issues or anything, but these are the things that I had identified for the committee. So, and I'm going to come back to the first one in a minute. So one of the things was restricted titles as opposed to terms. A notary public who is not an attorney licensed to practice may not use the title notario. Otherwise, it sounds like you can never say that word if you're a notary, which nobody intends that. The next one was adding an effective date. And here's a little bit of the tricky part. And I had included in the chart, the comparison chart, the law that you passed last year that did two things. It dealt with that kind of in-person notarization because of COVID. The governor had issued 2 executive orders. The bill you passed last year continued that process. We wrote it into statute. We said that's going to keep going, and we're going to direct the Secretary of State to start looking at this and look at not only Rolona, but specifically the part that deals with remote online notarization. So because the executive order wasn't dealing with online notarization, but that statute that you passed last year that said, here's our gap between the executive order and the recommendations from the Secretary of State, ends January 1st, 2023. The effective date of this bill is going to be July 1st, 2023. So it makes sense to at least extend the gap filler until July 1st, 2023. So that's 2 amendments that were not included in the bill. They're on your comparison chart, moving those dates in statute to July 1, 2023. And then we get to do this little effective date dance where we want that to take effect before July 1st. So we need to say, okay, that will take effect in 90 days, your usual effective date for legislation passed by the legislature. But the rest of the bill, so except for Part C, the rest of the bill is going to take effect on July 1, 2023. So if you go ahead with the whole Rolona and putting it into main statute, there are the cross references and there are the things going on in Title 19A. All that would take effect on July 1st, 2023. The law itself would stay in effect until that point. The current law would stay in effect until that point. So those are kind of I hate to call them technical because they actually do have very significant effect, but they're kind of housekeeping questions. And then the last piece in this amendment is actually something that we talked about in committee when it looked like, so the bill removes from a notary the authority as a notary to conduct marriages. And it creates a new license called marriage officiant. So the marriage officiant, the current law says who can conduct a marriage. It's a judge or a justice, a lawyer admitted to the main bar, a notary under this Title IV provision, and that's all in Title 19A, Section 655. When you were looking at the bill last week, it had this cross-reference, and it seemed kind of confusing because we were saying it's in the conflict of interest provision for the notary, and we were saying, wait, it says, up here that the notary can't conduct we're taking away that authority to conduct a marriage ceremony. We're saying there's a conflict of interest if a notary does any notarial act for somebody that they're related to. And then we've got this paragraph C that says, notwithstanding these things, a notary can conduct a marriage as authorized in 19A. Well, that's because if the notary is a judge or a justice or an attorney or this new category of a marriage officiant, even if they're a notary, they can still go ahead and do that for a relative, and that's not a conflict of interest under the notary law because they're not doing it as a notary, they're doing it as one of these other people who are authorized. So that's what this amendment does. I realize that you haven't decided on whether or not that's how you're going to go forward with what a notary can do. But if you stick with the bill, then this amendment makes sense, I think. Okay. Do you have any questions about all that I just ran through at top speed?
Committee members?
I'll stop sharing.
Yeah, thank you, Peggy. Those are really great points for us to be aware of as we move forward. Let's see, committee members, questions for Peggy. Representative Reckitt. We're not able to hear you, Representative.
I hate to back up to what you just said, but I need to understand it in what I probably tackily call understand it in English. So it's I'm complicated now on the on what's possible or not possible. So are you saying that a judge, let's say, for instance, because I think that's the clearest place I could go, a judge can indeed marry somebody who is in those categories?
Who's related?
Yeah.
Yes.
Okay. So that's, but prior to this.
Yes, they could.
They could, but
yes.
A notary couldn't.
A notary could because a notary has an exemption. That's the exception to the conflict of interest.
Oh, okay. But now that, so for a couple, 3 months, folks like Representative Thorne and myself could continue to marry people. And then when the new law goes into effect July 2023, unless let's say we don't register as an officiant, then we wouldn't be able to do any of that stuff. But if we did re-register as an officiant and somebody was crazy enough to let us do that, then we could indeed or not indeed marry a relative. I mean, not us marry a relative, but marry
I gotcha. Officiate at their marriage.
Yeah, thank you. Yeah.
Right. Yes, I don't think there's any, I mean, that's one of the reasons why they're thinking of creating this marriage officiant license is for the people who want to participate in their family members' weddings.
Okay.
Yes.
I think I got it now.
Right. The conflict of interest is in the notary statute. It's what a notary can and can't do. Currently, a notary cannot engage in a notarial act on behalf of a relative, except for conducting the wedding.
Okay. All right. Thank you.
And Peggy, aside from the conflict of interest issue, there is still a provision in the bill that's presented to us that current notaries have maintained that authority to solemnize marriages for, is it 4 years from the effective date?
It's 4 years from the effective date. If they are a commissioned notary on the date the new law goes into effect. So there's one provision that says if you're a notary, your term, so the notary terms right now are 7 years. When this law goes into effect, you still keep your commission for the rest of that term. So if you were commissioned in June of 2023, you've got your notary commission for another 7 years. In addition, at when this law goes into effect, the Secretary of State's office will issue the marriage officiant license to everybody who is a notary on that date. If they want it. If they don't want it, they can, refuse to take it. So they will have that. If you're not a notary, they're not going to give you a marriage officiant license automatically. You'll still have to apply.
Okay. Except for having no idea whether when my expire, I have to look. I'm fine. I'm clear now, I think.
Okay.
Yeah. Just the point being that there's not a hard cutoff on January 1, 2023 of your ability to perform weddings.
Right.
Yeah. Thank you, Peggy. There's some other questions, Senator Sanborn?
I don't have a question, but I wanted to make a motion not to pass as amended. I think this bill has been incredibly well done by a very committed stakeholder group. And I wanted to direct the committee's attention to an email that we just received as we were meeting from one of the members of this group. She says she didn't realize that she should be present because she thought that there wouldn't be any concerns. So she asked that we not take their absence at the last work session as any kind of concern or not lack of support for the bill. But there was very strong support on the working group. And I think that this bill came together really well. It's a very complex and technical set of issues. And I urge the committee to vote to pass as amended.
Thank you, Senator Sanborn. Is there a second? Senator Keim, are you a second on this? No, okay. Seconded by Representative Moriarty. And now we can continue with questions for Peggy, but also committee discussion. Senator Keim, go ahead.
Thanks. I think last time we didn't actually fully go through the bill, and I don't remember any discussion at all on the process of remote notarization. Am I wrong, Peggy, on that?
No, you are absolutely right. I skipped over that and said, this is something, rather than doing it in the middle of the bill, it would make sense to kind of go over in detail. The Secretary of State's office has put together an outline of that. And I'm not sure if it's Julie Flynn or Kathy Bodwin would be happy to walk you through that process. And also, I think Caitlin Wolf is here from the Uniform Law Commission. She's the attorney attached to Rolona, and so she might be able to walk you through that process as well, because it's basically the same process in the bill as it is in the uniform law, I believe. So that the remote online notarization is section 1915 of the bill. If you're looking at my chart, it's on page 12. It goes through all the definitions, all the process. It talks about identity proofing, what technology you need to use before you go through this process. You have to be in touch with the Secretary of State's office so they can make sure that you can handle all the aspects of this. They're video recorded. The whole process is video recorded, and what it says at those videos have to be retained for at least 10 years unless the Secretary of State adopts rules that are different than that. But if I can do one thing, I can pull up their remote notarization process. And I did send that. It's also posted, but I'll share it online. And I don't know if somebody from the Secretary of State's office or Caitlin Wolf would like to walk you through that. It's up to you how you want to deal with that.
Yeah, I was just going to ask if we could have one volunteer from the attendee part of the meeting who would be best to speak to the remote notarization process. You know, that Peggy suggested was either Kathy Bodwin, Julie Flynn, or Caitlin Wolf. And could one of you just please raise your electronic hand, and we'll bring you over to the panel to walk us through.
Did you get Julie?
Before we go there, if I could just ask one more question to Peggy.
Yes, please do.
Just to go back to the marriage officiant license. So this bill also creates that as well?
It does.
Okay, I just missed that part. Thank you.
And Soupy, could you please bring Julie Flynn over to the panel? Thank you. Welcome back.
Thank you.
Julie, would it be helpful to you if Peggy screen shares as you explain the remote notarization process, the kind of one pager?
If it's helpful to the panel, that's fine. I've got it on paper in front of me, but I think if you all can see it, that's probably helpful.
Yeah, I think so as well. Thank you. And I'm just going to let you go ahead and provide a narrative explanation of the remote process. And committee members, if you have questions, raise your electronic hand. And then Julie, if you can pause every now and then, and we'll take any questions that arise. Thank you.
Okay, great. And I'll start for the record to just say I am Julie Flynn, the Deputy Secretary of State. I live in Windham, Maine. I have been overseeing the Bureau of Corporations, Elections, and Commissions for just over 27 years. I passed my 27th anniversary earlier this month. So I've seen a lot of both notary corporations and elections issues in my time. So this remote notarization process, one of the things that the bill does is say that if you're an existing notary, before you can perform remote notarizations, online notarizations, you would need to notify the Secretary of State and indicate that you are using a communication technology that is approved by the Secretary of State. So we'll create a form for that so that people can make that designation, and that we will be able to have a list of people who are authorized to perform these remote and online notarizations. Before you conduct a remote online notarization, and if it's helpful, I'll use the shortened version, RON, just to save my words, but the notarial officer must have personal knowledge of the identity of the person that they are performing the service for, or to obtain satisfactory evidence of the identity through two different types of identity proofing. So just like with any notarial act, if you're performing a notarial act for someone who's personally known to you, you do not have to ask them to show you ID. That would be the same in the RON process. If I'm doing that for someone that is personally known to me, that's the identity proofing. But if not, then you need to have the satisfactory evidence. So the remote signer can present their government issued ID to the camera, and the notarial officer can verify that and put that information in their journal. Or they can do a credential analysis. It's done by a communication technology vendor, and it's an automated process, making sure that they have algorithms written for this so they can make sure that that credential is a valid credential. And then there's an ability to do a knowledge-based authentication, again, using this communication technology vendor. And part of the process that we'll have to be doing between now and July 1 of 2023 is to adopt rules and to lay out the process by which we will provide, approved communication technology vendors that notarial officers can use if they're going to do this process. And so the knowledge-based authentication, requires the signer to answer a series of computer-generated questions based almost like your security questions that you set up in banking. There's information that's known about you, and you would have to answer questions about it so they can verify that you are who you say you are. So the notarial officer confirms the record that is in front of them. That's going to be the subject of the remote online notarization. And they need to confirm that what the person is signing remotely is the same document, that the person made a statement or signed. And there is going to be an electronic journaling of this process. It's part of the service that a communication technology vendor would provide, that they can capture the electronic journal entries for this, as well as create the audio video recording of the event. The notary has to apply their electronic signature and stamp. And then if they are doing this remotely, but they have a tangible paper record in front of them, the notarial officer would take an acknowledgement of the signer, and the record is displayed, it's identified by the remotely located individual during that recording. So they're showing that and indicating this is the document that I am signing on paper rather than online. So the signer has to make a declaration under penalty of perjury, and that they are signing this, that this is their free act indeed, the things that they would normally swear to in doing a notarial, doing a signing. And then the declaration would indicate that, that confirms that this is the same record that was signed remotely. It would indicate the notarial officer, person who signed, the date of the transaction, and the printed name and signature of the individual who signed. And the record and the declaration are required to be sent to the notarial officer no later than 4 days after the notarial act was performed. And once the notarial officer receives the record and the declaration, they execute a certificate of notarial act. And the form contains the name of the notarial officer, the witness to signing using the communication technology, the name of the person that was remotely located who was the signer, and the date of the transaction. And there are a few things in the law that are prohibited to be done as a remote notarial act.
Julie,
yes.
My
Sure.
apologies for interrupting you. I just wanted to ask committee members before we get to the prohibitions if there are any questions about the process that was described. Representative Babbage, go ahead.
Thank you very much, Madam Chair, and good to see you again. Ms. Flynn, Julie. So the recording of this is new. My understanding is that journal and a stamp have been optional in the past. And I take it with the application of a vendor's technology, electronically transmitting the stamp is possible.
Yes.
What I would like to ask is, at what point is the document notarized? Is it during the process, at the end of the process, or is it once the certificate of notarial act is completed? For whose benefit is the certificate of notarial act?
I think it is so that the notarial officer has the certification. So once the certification is done, that's the notarial act is performed, but it's making sure that the notarial officer ends up with the certification that act occurred.
Okay. And so the Secretary of State's office is only involved in that they approve the vendor, the use of the vendor at the beginning of the process?
Yes, we'll approve what other states have done, have come up with rules, and we will approve multiple vendors. I mean, there are quite a few vendors out there. So that gives notarial officers some choice about that.
Okay.
And I think part of the process, the communications vendors, part of that, the service that they're going to offer is to make sure the notarial officers completely understands the process that's going to happen and is educated on what the requirements are.
Thank you. And I'm not seeing any other questions. Representative Babbage, are you done with your questions? Okay, thanks. Yeah. All right. Thank you, Julie, for pausing for questions.
And I know you did ask me that, so I apologize. I got on a roll there and forgot to pause. So there are, in the law currently, there are some notarial acts that are prohibited. You would not be able to solemnize a marriage remotely. So if marriage is stayed in as an ability of a notary to perform, or if you're doing it as an officiant, you're not able to do that remotely. Witnessing, when someone acts as a witness on an absentee ballot that's been delivered by a third person, or when someone has had assistance, that notarization process cannot be done remotely. When you are dealing with candidate petitions, or so the oath of the circulator that is notarized cannot be done remotely, nor can the candidate consent. I think those of you who are running again for a primary would have just turned in candidate consents by March 15th, and your consent could not be done or notarized remotely. And then the circulator's oath on initiative and referendum, people's veto referendum petitions, that oath could not be done remotely. I think, and also the signing of the application, when someone starts an application, puts in an application to our office to begin the process of an initiative or people's veto referendum, the 5 voters have to sign, and it either has to be notarized, or it can be just turned into our office and we can do it without notarizing it, but that would not be able to be done remotely.
And so just to clarify, all of these items would continue to be done in person as they are now.
That's right.
Okay, thank you. And I see that we have at least one question. Senator Keim, go ahead with your question.
Thanks. I have a couple actually. So in this section that you were just discussing, and to clarify then, there's nothing to do with elections that can be done remotely, or is there something to do with elections that it just isn't listed here? I just wanted to clarify that.
The things that are listed are the only things in the election law that require a notarization. So they would not be, none of those would be able to, nothing in the election law requiring notarization would be done remotely.
Okay, great. And then I know we also got testimony about keeping of records, and that in our law, I think reading it quickly, that we only allow them to keep one type of one type of online. I'm looking at this. So if anyone wants to know, this is the information we got from Notarize, which I think must be some sort of online database for notaries to use. Anyway, one of the suggestions they had, so I wanted to hear your response to this, was keeping an electronic journal. And I guess the law in front of us is saying that we would only allow them to use one platform or one journal rather than multiple. Was that a discussion point? And do you have any comments on that?
I think in terms of the notaries who opt to do online remote notarization, they're going to want to choose one vendor to work with for all their transactions. And so they'd use that journaling capability if that's offered by the vendor. I think some of the communications vendors offer some slightly different services. So as we go through the vetting process of those vendors, we'll need to make sure that we have a very clear understanding. I think I was not able to attend all of the work group meetings. I'm hoping my colleague might give me a sign about whether they went into detail on this subject. But, you know, for someone like myself, who I'm not doing titles, I'm not doing, you know, mortgage closings or whatever, I'm going to be doing wedding notarizations. You know, I'm going to have a paper journal. So that's what I'm going to use for everything. And so anybody who's not going to, you know, be doing both types of transactions. But we did say in the law that, you know, you'd only have one journal that would be kept, because I think it would be difficult if we're going back to try to figure out if something happened and we have to contact the notary to get a copy of a journal entry, you know, if they're doing paper journal book for some things and a online for others. So we did say that it was one type at one time.
So you're saying, so if a person though was doing an electronic, if someone was doing electronic notarization, they would have a journal, and it can't be more than one type of journal for electronic. But then if they're doing in-person notarization, they don't have to use electronic. They could have a notebook and electronic. Are you saying if they do any electronic, every single thing has to be in the electronic journal?
I think I'm trying to see whether, looking at some meeting notes here.
I am sorry to interrupt you, Julie, but I believe that Kathy Bodwin was deeply involved in this particular conversation. Would it be okay with you if I bring her over? I think that may help on this particular point. And let's see, she's joining the panel.
I guess I'll say while we're waiting, you know, we want all the records to be kept in one place. So I think how this was drafted was that you would keep only one type of journal, either electronic or paper.
We've been joined by Kathy Bodwin. And Kathy, your camera might be covered. You look very green. A week after St. Patrick's Day. Happy St. Patrick's Day.
Sorry.
But are you?
Yes.
Go ahead and help us with this issue, please.
Yes, thank you. So I'm Kathy Bodwin, and I'm the Director of Corporations, UCC, and Commissions. And so during the working group meetings, we did have discussions about the appropriate way to handle the journaling. And we had discussions, and we felt that it was better to have it all located in one place, have one journal. So pretty much because a lot of the vendors too, they will provide a means for the notaries if they are doing remote notarizations to keep a journal for everything. Or if it's a notary that is not doing remote notarizations, then they would have one journal, because it's important to maintain that record in a chronological order. So we did have those discussions, and that's how the group wanted to proceed. So
can I just ask a clarifying question? And so instead of writing out by hand in a paper journal, if you were doing both kind of notarizations, you would just type it into a journal on the service that you're using for the remote notarization?
They have options. So even if you're not going to perform, a notary is not going to be performing a remote notarizations, then they could keep an electronic journal of everything. They could still keep that electronic record of their notarizations. So okay. Does that answer your question? Is that what
I actually was focusing particularly on people who are doing both kinds.
Yeah.
And so can you just give us a little more kind of nuts and boltsy description of what somebody who was doing both remote and in-person notarizations would do?
Yeah, we kind of envisioned that there would, a lot of the vendors, the vendors offer different solutions. And so our envision was if you have a notary that is doing both types of transactions, remote and in-person, notarizations, that they would keep the record electronically through that vendor that they have contracted with. That's the means of the journal would be electronic, whether they're doing it remotely or in person. There would be a means for them to go out and keep that journal no matter what.
Understood. And I'm just wondering what that means from the notary's perspective. Are they, and maybe you don't have this information, but are they typing into the journal the information as opposed to writing it on a piece of paper?
Exactly. So they would probably be logging into the vendor platform. They would log in and enter in that transaction information.
Okay.
And
Thanks.
it would save it and maintain that information. So they'd have one journal, one electronic journal for both types of transactions. That's how we envision that working.
Thank you. I think that answers it. And Senator Kime, I interrupted your line of questioning. Go ahead.
Well, it's really the same line of questioning. And then I guess to me, that seems just a little bit cumbersome is that they can only keep, I understand the value of having one record, but if you're doing in-person notarizations, it seems easy to write something down and not necessary and a little bit cumbersome that they cannot keep both. I totally understand the electronic part being electronic, right? Because then you're there and you're electronic, but if you're in person, it seems easy to write something down. And so what would your response be if a person is, has been doing it in person and then opts to go and do it remote? Then what do they do? Then they have, part of theirs would have been written. Now they're switching into, over a 4-year period, I can imagine things might evolve, right? And then, so then they definitely do have 2 records, right? They have something that they were keeping and now they've changed. So was that discussed? And then I'll just follow up by saying what this one piece of testimony to us is stating is that this is the common practice, even though it's in Rolona, is that the common practice throughout the rest of the country is not to limit the notaries to only one journal.
Did you Kathy Bodwin or Julie Flynn, did you wish to respond to that?
I think, I mean, I understood that that testimony was from one particular vendor. I guess I'm not sure that that's the practice across the country, but I think it would be acceptable, Senator Keim, if somebody had been doing, they get the law passes and initially they don't want to have anything to do with remote or online, and they continue to use their paper journal if they were using one before, or for people who hadn't been using one, then they would begin using that. And then at a period in time, your journal would go up to a point, and then they would start using the electronic if they switch to doing electronic transactions.
And Senator Keim, I didn't realize that you were specifically asking about one versus multiple vendors, as outlined in that vendor letter. But I think that Caitlin Wolf, who is more involved in the kind of uniform multi-state aspect of this, might be able to address the question. So I'm going to bring her onto the panel as well. Welcome back, Caitlin Wolf. And have you been listening to the question about, okay, you can go ahead and answer.
Yeah. So I have been listening to a little bit of the questioning this morning and this afternoon, I guess, a little bit about it. So I certainly understand the concern. And I think just to sort of put a finer point on what Julie Flynn was saying. So we do require under RELONA, so under the bill in front of you, we do require maintenance of one journal. However, we all know with a tangible paper journal, it will eventually run out of pages, right? So an individual who wishes to switch over at one point, I don't think there's anything in the bill that would prohibit that individual from opting to switch from a paper journal to electronic. And then I think Kathy set out everything that I was going to say really about how the vendors work. You can still enter, through your vendor. If you're performing an in-person, traditional notarization, you can enter the data, the signer information, the date, what type of transaction it was into that electronic platform and maintain your journal that way. And then I guess, in terms of the more national approach, so in RELONA, the states that have adopted RELONA generally have adopted this language that does require the one journal, the maintenance of the one journal. So I can't speak to every single state out there, but states that have adopted RELONA have adopted this language. I don't know, Senator Keim, if that gets to your question or if you had a follow-up, but I'm happy to try to address it more if you'd like to ask anything else.
So you're saying that this testimony then is likely incorrect, where they say that that most of the states are allowing more than one type of journaling.
I'm trying to pull up the testimony that you're referring to, Senator Keim.
So I'll just read you the sentence. It says specifically subsection 2 explicitly states a notary is permitted to utilize only one journal at a time, regardless of whether the journal's format is tangible or electronic. While this provision is consistent with RELONA, it is not practical and is inconsistent with standard practices across the country.
Yeah, I see that now.
Excuse me, before you answer the question, Caitlin, Senator Keim, could you please let us know the name of the person who made that statement and where they're from?
It's a testimony to us dated March 15th, 2022, and it's from Notarize, which I assume is just an online platform. And let me see if there's actually It is from their government affairs and community engagement person named Kim Gadik, maybe? That's how you say her last name.
Thank you. Okay, go ahead, Caitlin.
No, I mean, obviously, the individual from Notarize is going to be more familiar with their platform, with that service than I am. But you know, again, all I can say is in terms of why Rolona was drafted the way it was we thought it was important that the journal be maintained in one way so that we're, you know, able to be chronological in how these transactions are listed, and that there is one comprehensive record if we do need to go back, rather than having the notary have multiple journals sort of strewn about. So again, that's kind of all I can say in terms of why we chose to have the one journal requirement. And again, you know, I can't go into more depth about Notarize and how that particularly works. So.
Yeah, and I don't think, I mean, I guess if you misunderstood that statement, I wasn't taking it to mean that they were talking about Notarize. They were talking about common practice in throughout the states, not necessarily their platform, but just in general, that the common practice was different. So that's what I was trying to get at, is to understand, is common practice different throughout the states, and are we doing something different here in Maine by restricting it to only one form of journaling? Because I guess what there's
and I think Senator Kime, I'm sorry to interrupt you, but I think we've exhausted this. I think we understand what the situation is.
Sure.
Thank you. Representative Babich, go ahead with your question.
Perhaps it's been answered. My understanding is that certainly should an electronic vendor be used, which has to be used for remote, that that using one vendor as the means by which to have an electronic journal makes sense. But I guess if we have Ms. Wolf on, or then as far as Rolona and this bill, we're talking about one journal being required for all notarizations. It would not be a practice to have a paper journal for in-person and an electronic journal for remote notarizations?
Yes, Representative, that is what is contemplated in the bill. One journal. Yes.
And there's no prohibition for multiple journals that are both complete?
I don't know that I understand the question. If you could rephrase that, Representative.
I mean, if I use a paper journal right now, there's no prohibition from me having an electronic journal that includes all notarizations going forward, whether they're remote or not, and me keeping my own copy for continuing my journal that I have now. Is that right or not?
Julie?
As long as they're complete, I'm wondering what the issue is.
Right.
Well, I think I liken it to the old adage that if a person has a watch, they always know what time it is. And if they have two watches, they're never quite sure. And that is, if you're not able to keep the identical information in both journals, I mean, one of them has to be the official journal so that we can go to one place. If there's a court case and it involves a paper transaction, but also an online or remote transaction, and they're in different journals, they're going to different places. So I don't think it would hurt. I think you'd have to change the wording in the bill to say they could keep a paper journal for paper transactions and an online for both. But
thank you, Julia. There's the wisdom of 27 years. I appreciate it.
And a great metaphor, actually, with the watches. Thank you. Committee members, I feel like we've covered this territory. I wanted to know if there were other subjects that we wanted to ask questions of either Julie, Kathy, or Caitlin before we move on to a vote on this bill. Representative Babbage, is your hand up with a new question? No, okay. Senator Keim, go ahead.
Thank you. I think Ms. Flynn, you're the person to ask this too. I was wondering, so right now, there's one test for becoming a notary. Are you envisioning that that test would stay that, like there would be two different tests and there would be a different test if you wanted? Basically, it's looking obviously like the remote notarization is more complex, right? And there's more issues around, like more stuff to know around that. Would you expect that there would be two processes for becoming a notary, or would you have to understand all of it in order to, I mean, would you have one test and you would be authorized to do both types?
I think when someone opts to become, that they notify us that they are going to, or make that designation that they're going to do the online notarizations, then I think there's a different level of information and education and testing that we may do for them. And this is something we have to identify in our rulemaking before the bill becomes active. But I think the initial test is going to, cover the basics. Obviously, it'll be different than the test we're giving now, but it will cover, the basics of the law as our current test does. And then, we may have a question about it, and certainly to make sure they know they have to designate that they're going to do it. And then that would subject them to additional testing. Or
Okay,
at least
so
educational requirements, possibly through the vendor. That if we're approving vendors and they, part of that might be that they would, somebody becomes their client, they've designated with us that they're going to do it, and this is the communications vendor they're going to use, that perhaps it might be something that we ask that vendor to certify that they've had that additional level of training.
So just talking about it sort of as how to enter in, do you envision that the entry process into that sort of first level in-person notarization remains somewhat similar to what it is now? I mean, obviously the test includes things about solemnizing weddings, which would be removed, but other than that,
I think so.
Okay. And then the further step to become remote certified or whatever is what you envision.
Right. And I think that some of the vendors that we talked to, we had a couple of demos as part of our study group. And some of them will, in order for them to take you on as a client, you go to them and say, I want to use your service. They want to make sure that you understand what's going to be required of you. And they may have an additional requirement before they'll sign you up as their client to make sure that you know what you have to do.
And all of these are just routine technical. They're not major substantive. So we will not be seeing. Okay, thank you.
In the bill, it's drafted as routine technical.
Okay, thanks.
Additional questions, committee members? Representative Harnett.
Thank you. And I do have a question for Julie Flynn. If I'm a traditional notary public, and I have no interest in being certified, I have no interest in doing electronic notarization. Is my life going to change? My responsibilities?
Well, you're going to have to adopt a journal if you haven't been doing it voluntarily. And we're going to have to send out a communication to the existing notaries to make sure they're aware of the new laws, what's covered, definitions of notarial officers. But How you do your transactions, the notarial certificates, that hasn't changed. So much of your practice won't be different other than where the law has changed.
And could I choose to not participate in the electronic notarization and just keep a paper journal?
Yes.
Okay, thank you.
Committee members, any other questions? Senator Keim?
Thank you. I did have a question about the choice not to have someone be a citizen. And so if you could just go over that, that was part of, and I don't know who's best to go over it, but that was part of Rolona, wasn't part of our law, and then it was chosen not to adopt the citizenship portion. Oh, and can I just ask one clarifying question to Representative Harnatz before we change subjects? He asked if anything would change. Do they now have to have a stamp? Is that right? Is that different? Like right now, currently, they don't have to have a stamp, but they will have to in the future. Okay,
Right.
so that will be a somewhat of a difference because they'll have to purchase that.
Right.
Okay.
Sorry.
Yeah.
Thanks for.
Yeah. I thought I read that. Okay. So yeah. So could you talk to me about that and tell me what the thought process is there?
In Title V, the law didn't specify that someone had to be a citizen or not, but because we were using the oath that is in the Constitution that says you have to swear that, so long as I remain a citizen thereof, this issue first came up for us in 2009, back and found the testimony of my person who was the director of over notaries at that time. And we had several complaints from people who were, non-citizens who told us about a Texas, a U.S. Supreme Court case. It's Bernal v. Fainter, Bernal v. Fainter. It's from 1984. And I think the Supreme Court ruled that the Equal Protection Clause of the 14th Amendment to the U.S. Constitution prohibited the state of Texas from denying non-citizens the right to apply for commission as notary public. So I think that John Bolton may be on in the waiting room or may be able to speak to that, but
I'll try to, Julie, I'll try to bring him on. Give me just a second. Let's see if he's.
I'm not an attorney, but I know that for us was sufficient that we asked the legislature to put an oath into statute that we could use just for notaries that didn't require them to swear they were a U.S. citizen.
Okay, and he is joining us, and he's indeed here.
Good afternoon.
Hi, welcome back. Did you hear Senator Keim's question about the change?
I did. Yep.
Okay. You can go ahead.
Sure. So Julie's exactly right. I think the concern is this Supreme Court decision from 1984, Bernal versus Fainter, and basically the general rule is that although the federal government has a lot of discretion to apply different rules for aliens versus citizens, states have far less discretion under the 14th Amendment. So when a state wants to enact a qualification, that says you have to be a citizen to do X, federal courts will look at that under what's called strict scrutiny, which means that essentially the state has to have a compelling interest in the classification, and that the classification has to be narrowly tailored to further that compelling interest. And so it's a very difficult standard for states to meet. And so in the Bernal case, Texas, had this law that said you had to be a citizen to be a notary, and the Supreme Court found that the reasons that Texas put forward for why they would have that classification or that requirement didn't pass muster under the very high standard that would apply. And as far as I can tell, Bernal is still good law. So I think if there were a citizenship requirement, it would be, potentially vulnerable to legal challenge. And I assume there are, in fact, non-citizen notaries commissioned in Maine now. So those folks would potentially lose their commissions.
Can I ask a follow-up?
Yes, go ahead.
So since it's a Supreme Court decision from 1985, why would a citizenship requirement be placed in Rolona in the, standard language if it is a conflict?
That's a good question. I actually don't know the answer to that. I do know, I actually Googled a little bit to try and see if I could shed some light on this. And I found a report in Oregon where they took out, I guess, or I don't know if this was actually ever enacted into law, but I did find a report where they were discussing how they didn't feel that the Rolona citizenship requirement could be put into their statute because of Bernal. So that's one data point. But I don't, you'd have to ask somebody at the Uniform Law Commission, why they think that that's appropriate.
Perhaps I know Julie's hand is up, as well as, I don't know if Caitlin, if you can address that as well, but Julie Flynn, could you help us out with that, please?
Well, and interesting, I didn't remember this testimony, although I probably helped write it and certainly proofread it before it was given. But what we're saying, that the Supreme Court decided that since the duties of a notary are essentially clerical and ministerial and do not involve, quote, policy-making responsibility or broad discretion in the execution of public policy, end quote, the state could not justify requiring a person to be a citizen in order to become a notary public. So that's part of the justification that was in the decision, if that helps.
It does. I guess maybe if Mr. Bolton, if you would have a response to this, but if we're allowing them to notarize a campaign, like election, issues, and they're not citizens, that seems, I don't know, strange to me.
Yeah, so I think, I guess what I would say about Bernal is that, it looked at Texas's justifications for the requirement, and it found that those were not, I think, pretty in pretty dismissive terms, found that they weren't sufficient. And the specific interest that Texas was asserting was that citizens, would be less likely to know the laws of Texas, or non-citizens would be less likely to know Texas laws than citizens were. And they might be more likely to leave the country, so they'd be unavailable if they were needed for testimony. The Supreme Court said that those are not even close, basically, to compelling interests that would allow this classification. So, that doesn't exclude the possibility that somebody could come up with, or there might be some other compelling reason out there that could conceivably pass muster. But I think that this, if you read the decision, it makes it pretty clear you'd have to have a very strong, well-reasoned case for this that would have to be backed by evidence that shows there's a problem that needs to be addressed here. And I think one of the issues would be, given that Maine has in the past allowed non-citizens to be notaries, it might be difficult to make the showing that unless there has been problems, and maybe there has, and I'm not aware of them, but if it's been doing this for years and there haven't been problems, that would would certainly be something that would come up in a legal challenge.
Thank you.
All right, I think we're all set with that question. Thanks everyone for your contributions. Representative Harnett.
Thank you, Madam Chair. I would like to call the question.
Thank you very much. We have a call the question. Is there a second? Seconded by Representative Newell. And there are lots of hands up, And Representative Harnett, can you remind me, is calling the question a debatable motion?
I believe that it is not, but I'm recalling the last time we had one of these. I cannot answer that with certainty.
Peggy, are you able to remind us of that?
That is not something I have any knowledge of. Sorry.
Okay. Steve Moriarty, who is very familiar with the rules, has just joined back on the meeting. Representative Moriarty, can you help us clarify that? We're not able to hear you.
Thank you, Madam Chair. It's not debatable. We go immediately to a vote on the main motion.
Okay.
Made by Senator Sanborn.
Well, first, so we don't even vote on calling the question?
Well, if the question is called, first of all, you don't debate the motion to call the question. You vote on whether to call the question. If that motion passes, you go immediately to a vote on Senator Sanborn's motion.
Thank you. Okay, so we will take a vote on whether to move on to the question. Representative Harnett?
Thank you, Madam Chair. And this is a question for Representative Moriarty. Under Robert's rules, it requires a 2/3 vote. Is that your understanding under the legislature's rules?
I don't recall that. I know it in my town council days, it was a simple majority vote.
Okay, thank you.
I also believe it is a simple majority, Representative Harnett.
Thank you.
We follow Mason's rules. Okay, so committee members, we're going to vote on Representative Harnett's motion to call the question, seconded by Representative Newell. And Soupy has arrived. We're ready for the roll when you are, Soupy.
Okay, thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
No.
Representative Babbage votes no. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
No.
Representative Libby votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 7 members voting in the affirmative, 5 members voting in the negative, and 2 members are absent. That is the vote of the committee.
Thank you very much. And I would just like to thank those participants in this discussion who are on the panel. I'm going to move you, and actually, Soupy, could you move non-committee members back into the attendees part of the meeting? Thank you. And so the question has been called, and now we move on to a vote on the underlying motion, which is Senator Sanborn's ought to pass as amended motion, which was seconded, I believe, by Representative Moriarty. And Soupy, if you could, when you're available to return and call the roll on the underlying motion, we'd appreciate that. Oh.
More than happy to. One more move.
All righty. Thank you.
This is on the motion.
Yes.
Senator Carney.
Yes.
I'm sorry. Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Libby. Representative Thorne.
I recall during one roll that Representative Moriarty was able to explain why he was voting a certain way and how he may vote another way on the floor, and he wasn't stopped. So I would like to say that the reason that I am voting yay on this bill is because for the first time ever, a sponsor of a bill called me up this morning, Secretary of State Shanna Bellows, to explain the concerns that I had with this bill. For those reasons and that reason only, I am voting yay.
Thank you, Representative Thorne. Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Libby. Representative Libby is absent. Madam Chair, I have 9 members voting in the affirmative, 0 in the negative, and 5 members are absent. That is the vote of the committee.
Thank you very much. So the ought to pass as amended motion carries 9-0 with 5 absences. So that will conclude our work session on LD 2023. And we are going to move on to our next, actually, we're done with work sessions. We do have a language review on LD 1945. And Peggy, I will turn it over to you.
All right, thank you. So at your last work session on 1945, which is a bill to protect biometric identifiers, am I getting that right? An act to regulate the use of biometric identifiers. You had a pretty thorough discussion, and then you voted, and of the people who were here, you voted about half, a little more than half voted in favor of Representative O'Neill's amendment that she brought in that kind of tightened the bill itself. And the rest voted ought to pass on just doing a study. So I have both of those amendments out to you, and I know that and I can talk about them. And I just want to let you know that I've been trying to work with the Attorney General's office on the statutory one, not the study one so much, in order to make sure that we're not creating problems for the state to have to defend if this law goes forward. So are there First Amendment issues? Are there, Commerce Clause issues? And I just wanted to make sure. And so some of the language that I sent you yesterday was based on some recommendations from the Attorney General's office. And I know that Representative O'Neill is uncomfortable with some of that language. And so she is working on an amendment that would make some of those changes. But I'm happy to walk you through both the study. So when I ended up working on the study, I had done an early draft. And when I finally got back to the study, I kind of pinned it on the committee amendment with the statute going through. So rather than putting all the details in the study, it refers to chapter 1057. Because I think one of your options is to put a delayed effective date on the statute part, bring the study in and try to refine what's going on in the statute before it goes into effect. So make sure that you know what you've learned from other states, what you what's defensible by the state, and any other issues that you want to deal with.
Peggy, before you screen share, first of all, thank you, because I know we did ask you to look into that language for the study. And then secondly, do you need more time to continue to work with the Attorney General's office, or were you able to address those issues?
I was saying paper off my pad. I didn't want you to have to hear that. I think that what I would really like is I need to get an idea that the committee is pretty close to going forward with whatever language you want to do. I think the one piece that you might want to talk about is adding a findings section. That's not something I want to throw together fast, because I think that's a really important piece for the legislature to express why, if you do indeed, why you think it's important to regulate biometric identifiers. That is not something I have. It's something I talked about with the Attorney General's office. And I know that Representative O'Neill has submitted lots and lots of testimony with citations for all those reasons that you would want to kind of condense and put in findings, and certainly other people who had testified. So it's part of the legislative record. The question is, do you see a need to put it into statute? It's something that needs to be carefully drafted. Not that anything else shouldn't be carefully drafted, but I think you should take some time with that, or I should take some time with that, or if you're going to go forward with that.
Okay, thank you. And I see before we get to the screen share on the documents, Representative Moriarty has a question.
Yes, thank you, Madam Chair. When we voted on this earlier, there was a 5-member minority of the committee which voted ought to pass as amended with a, according to my notes, a stakeholder process or committee involved. And I wonder what official record we have with Soupy on the text that accompanied that amendment, that amended version.
I think. Oh, go ahead, Peggy, because that's
I'm not sure that you had text at that point.
Well, not. I don't mean. I mean, what was the language of the motion ought to pass as amended? What was the amendment?
So, Soupy, go ahead.
No, I'm just here to answer questions, but I think that is a Peggy question. I can answer number questions. Peggy's the wordsmith.
And so I think that there were 2 ought to pass as amended reports, one of them being passing the bill with some amendments, and the second one being a study. And which one are you asking for the language on, Representative?
On the study, how that was phrased at the time of the vote.
So the vote was an ought to pass as amended vote for the text, for statutory text. The people who voted no, so the minority report at the time, it was 6-5 with 3 absent, and I don't, Soupy would have to catch you up on those. The no votes were ought to pass as amended, and this is what I wrote down, so it might not be verbatim. Stakeholder process reports to Judiciary 12/15/22 with authority to report out legislation in the 131st.
Okay, thank you, Peggy. Madam Chair, just to follow up, I had voted originally with the ought to pass as amended on the ought to pass as amended side. Having voted in the majority, I would like to reconsider the process so that I can join those who voted ought to pass with the stakeholder process.
Okay, and I'm sorry, my phone is ringing in the background, but do you wish to do that now, or do you wish to do it after? Because I think that there may be a reconsideration as well for others who want to potentially combine both the bill with the delayed implementation date and the study. And so I guess my question is, do you want to reconsider now and change and then potentially reconsider again? Or would you like to hear a little bit more about where the committee is, different committee members are considering going?
Okay, I guess I would just as soon do it now and to clear the decks of this particular issue.
Okay. Okay. And so I'm sorry. So you voted with the 6 on the ought to pass as amended the text.
Yes, I did.
And you have moved to reconsider. Is there a member who also voted with on the ought to pass with the text who would like to second the reconsideration? Representative Babbage has seconded. And so this is on the motion to reconsider. So not on the underlying issue, but just on the motion to reconsider. And Soupy, could you please take a roll call on the motion to reconsider?
I would be more than happy to, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Libby. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. I apologize. I think I skipped. Representative Poirier. Representative Poirier is absent. Representative Libby is absent. Madam Chair, I have 9 members voting in the affirmative, 0 in the negative, and 5 members are absent. And that is the vote of the committee.
Thank you. And now is there another motion? Representative Reckett.
Yeah, I am now thoroughly confused. I have tried to pull up the documents that Peggy refers to, and I'm fearful that the last one I pulled up is not the one she was talking about, because A, it's dated yesterday, and B, it had an effective date different than what she articulated as December of 2022.
Oh.
Mine says November. So where am I stuck here, Peggy?
Well, that's probably my fault. Because I went back to the standard template that we use for drafting this amendment, drafting the study, and that's my fault for not including what I had in my notes. We just have we have the first Wednesday in November as a reporting date in even years. And I didn't go back and check my notes to make sure that it would match with what was requested. So that's my bad. So the study is actually, I think that's the correct one right now.
Okay.
But as I said, it doesn't actually identify all the issues. It cross-references Chapter 1057, which the other amendment enacts. And if you're not combining them, then we'll have to put more details back into the study.
And also, Representative Reckett, we're not quite there yet, because before we're going to review do the language review. Representative Moriarty had asked for a reconsideration. And so right now we're looking for a motion on the reconsideration so that Representative Moriarty can change his vote. And so Representative Newell.
Thank you, Madam Chair. I just had a question. Might I ask the results of the first vote?
Yes, thank you.
And this includes everybody. It includes those that I got votes that you initialed and that were sent to me by email. 8 members voted in the affirmative. That would be ought to pass as amended. 5 members voted the ought to pass as amended, and I put in parentheses stakeholder. So if that helps. And 1 member voted ought not to pass, for a total of 14.
Thank you. Can I ask a follow-up question, Madam
Yes.
Chair? For a motion to reconsider this bill, should we not hear from the bill sponsor or?
Yeah, so the bill sponsor is joining us. She didn't have a link, and she was also in law school class earlier today. So she is joining us. But I understood that Representative Moriarty wanted to change his vote, in particular with regard to the passing the text versus the stakeholder group, and that we might indeed do another reconsideration, which is why I had suggested that we consider delaying it, but he was very interested in moving forward at this time. And so I guess we've passed the motion for reconsideration. If there is no motion that anyone wants to make right now, then I think that I believe we can continue on with our discussion. Representative Moriarty?
Thank you, Madam Chair. This question may go to Peggy. Now that we have chosen to reconsider, do we immediately go back to Representative Evangelos' motion of March 2nd, which was ought to pass as amended with that day's amendment?
No, I think you have cleared the decks as you described it. So I think you have nothing pending.
Nothing pending then. Okay, thank you.
Yeah, and so it would be my preference that we continue. Well, and now I think what I would like to do, because now that we have reconsidered and quote unquote cleared the decks, I'm not sure that it makes sense to go forward with the language review. And so I need a 5-minute break to figure that out. And so what I would like to do is, okay, so it's 1:13. Let's recess until 1:20, everyone. And that'll give me a little bit of time to figure out where we are procedurally on this. Thanks, everybody.
Okay, thank you.
Chris, you're hot.
You're listening to the sound of my mind.
I said it again.
Hello?
Representative Moriarty, you're
Hi, committee members. If you are at your desks, could you please reactivate your video? Thank you, everyone. I just wanted to let you know that we're continuing to address some questions. I haven't been able to get answers yet. I just wanted to give people an update on the time and let you know that we'll be in recess until 1:30. At that point, we expect to have all of the bugs worked out and be able to provide folks with some information about where we're headed. So thank you once again for your patience, and see you all at 1:30. All right, everybody, committee members, if you could please return to your desks and activate your cameras. And we'll resume our committee meeting. Thanks everyone for rejoining. And Representative Thorne, your hand is up. Can you just tell me what you wish to address the committee on? Because I have some announcements that I also want to present. And
before we lose or get lost for the day, a procedural question as far as what rules that we follow here in the committee, Judiciary Committee. Is it a Masons? Is it Roberts? Is it parliamentary? Is it a combination? Or is it otherwise specified what is required for each vote? For example, call for the vote. Does that require a simple majority? Is it a 2/3 majority to proceed? I'm just curious going forward, just for my knowledge on committee procedures.
Yep. I'm going to address that as part of the announcements. Thank you for raising that. Representative Reckitt, can you just tell me the subject of your question or what you'd like to address the committee on?
Not if you're going to address it. I was reading Masons while we were in that other debate, so I had input, so I pass if you're going to address it.
Thank you. I'm glad we're all thinking and being concerned about that. Right now, we are in the work session on LD 1945. And so I want to make an announcement about that first. It appears that this morning, while we've been working on other bills, that the bill sponsor is continuing to work on language that she hopes that the committee will consider. We don't have that language. And I know that there are many people, we don't have it yet. There are many people in the attendee part of this meeting who are very interested in LD 1945 and are here because they want to weigh in on the work that we are going to do on that bill. And so we have a reconsideration. We're kind of have a clean slate at this point. And I think what makes the most sense now is to get us to the place where I thought we were this morning, where we have clear language that we can circulate to everybody in advance of our vote on the bill so that there is no confusion and everybody understands where we are and can comment on what is under consideration by the committee. And because the ground has changed a little bit and the sponsor may be asking us to make additional changes, what I would like to do is not quite yet, but to request a tabling motion so that we can come up with an amended version of the language, circulate it in advance to all of the interested parties who are here today, and with apologies and respect for all of the time you're investing in this. It just makes a lot more sense for us if we can start with a document that incorporates changes rather than trying to read them to people and do it in this format. And so committee members, before I request a motion to table, is there any question on the process for 1945? Okay, I am not seeing any committee member questions. Oh, we've got a couple. Representative Evangelos.
Thank you, Madam Chair. Just my own clarification. Could Peggy or Soupy give us a screenshot of the votes we took and what the motions were? I just want to make sure I'm not getting confused here.
Right now on 1945, there's a clean slate. We had a vote, we had a reconsideration, and so that previous vote is no longer a vote. But we can, certainly we could screen share it if you'd like.
I just want to take a peek at it to make sure where I am. I know we're starting over.
Okay.
Thank you.
I don't know if that's possible, but Peggy, is that possible?
Right. I'm just not sure what you're looking for, Representative Evangelos, just how people voted.
Yeah, the vote sheet,
The original, the vote sheet before today.
before today.
Right. I mean, that's something Soupy has, but it's not an electronic format.
Just in my head, we had Representative O'Neill presented 2 privacy bills, and my brain is getting a little confused as to if I saw the voting sheets, then I'd know where we were. Are we on the? I know Representative O'Neill was disappointed on one of the bills. We ended up on a study group. Is that the bill we're on? Is that where we are, or are we on the other bill?
So I believe the 2 privacy bills are the constitutional amendment, which did not end up in a study group. It was reduced for the people who voted in favor of it. It was only 1 section as opposed to the 3, I believe, that she recommended.
Right.
That she had sponsored. So that was one privacy bill. I think that's one you're thinking of. This
Right,
is the other one.
Section 1, I think we
Yes.
added 1 word. Yeah.
On LD 1529, right. So this is the other bill, 1945, and it
This is the one where the study group, right?
so you divided, it was 8-5, 8 in favor of actually amending the bill with her amendment, 5 for the study group. And you came back today and reconsidered. So that's gone now. There's no vote on it anymore.
Okay, I'm up to date. Thank you.
Okay.
All right, Representative Newell, are you all set as well? Okay. All right, committee members. Give me just one moment, please. Thank you, everyone. And so committee members on LD, Representative Babbage?
I'm prepared to make a motion if you're.
Thank you. I was just going to
Right.
request a motion. You may go ahead.
And I move to table LD 1945, Madam Chair.
Thank you, Representative. And is there a second? Seconded by Representative Newell. And Soupy, if you could please take the vote on the tabling motion.
I would be happy to, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Libby. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I will recall the absentee. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 members are absent. That is the vote of the committee.
Thank you very much. And so committee members, LD 1945 is tabled. And so we will close our language review on 1945. And to all of those interested parties in the attendee part of the meeting, you will be receive the interested parties notification and updated language when we have that available. And now I would like to take a step back to address something that a bunch of committee members were looking at during the recess, which I was as well, We're going to reopen the work session on 2023, which is Rolona. Or we're going to return to Rolona because we're not technically in a work session. But what I learned during the interim is that Masons requires just a simple majority vote for calling the question. Robert's Rules of Orders requires 2/3. And although we follow Masons in chambers, Roberts is what the legislature typically follows in committee. And so for that reason, the motion to call the question failed. And because of that, we are going to reopen the work session on LD 2023. And so everybody ready to continue with the work session on 2023? Representative Evangelos.
Thank you, Madam Chair. I don't know if it matters, but I think on the House floor, a motion to move the question requires 1/3 of the people voting and present. I don't know if it's different in committee. I think the committee makes its own rules. I read the committee rules. We didn't stipulate the requirement on this particular item in our rules. But I know on the House floor, it's 1/3 to move the question, and then 2/3 with Roberts and 50% with Masons. So
okay,
my 2 cents. I'm not taking a position.
Okay. Thank you. Thank you. Representative Newell?
Thank you, Madam Chair. With what you just mentioned, having had a vote, where put us now, if you're going to open the public hearing?
Yeah, thank you for the question, Representative Newell. So we're kind of unwinding the clock a little bit. The motion to call the question failed. And so we need to reopen the work session on that because the motion to call the question failed. And then we immediately moved on to the question, which by virtue of being appended to the motion that we thought had passed but failed is not appropriate. And so what we're going to do is we're going to reopen the work session. We're going to see if there's any additional committee questions or discussions on LD 2023. And then we do still have the pending ought to pass as amended motion by Senator Sanborn. And so at the appropriate time, we will vote on that motion. All right. Everybody set? Does anybody have concerns about that path forward? Representative Thorne?
Thank you, Madam Chair. The only concern that I have is that there's at least one committee member that was present at that time that is not present currently as we reopen and discuss, that was in the middle of a line of questioning. And for that reason, I just wanted to be on record that, we're after the fact. I respect the fact that we're opening it back up, but there are committee members that I believe had other questions that aren't with us currently. So that's just an expressed concern on my part.
Yeah, I appreciate that. And I appreciate you raising that. And I, like you, I wish that the committee members were still with us. And I'm not sure what we can do about that at this time. But thank you for raising the concern. Representative Babbage, did you have a process question before we move on to the work session?
I can speak at either. I need to explain why I voted as I did. That's all.
On why you voted as you did on what?
Yeah,
on which I'm not asking for the explanation. Is it on the
reconsideration? On reconsideration.
I feel like the committee time is better spent moving forward.
Okay.
And
Let's
so
do
I
it.
would just ask that you let us go forward with that. Okay, committee members. And so we are returning to the work session on LD 2023. And I would ask if committee members have any additional questions or committee discussion on LD 2023, the Rolona bill? I am not seeing any additional discussion on the Rolona bill. Representative Babbage, go ahead.
Do we need a new motion, or are we using existing motions? Did you understand what I said?
I did understand what you said, and it's my assumption that because the calling the question was not, did not pass, that we are proceeding under the pending motion that was made earlier in the work session.
Then if it's okay, Madam Chair, this is the opportunity I have to very quickly say, I may be responsible for us to having to do this, whereas it didn't make a 2/3 threshold. But as usual, I'm usually sensitive to those that have a pertinent question and need to have it answered in order to vote. So I did get my answer. It was after I cast my vote, but I wanted to explain the reason that I did vote as I did on the procedural motion. Thank you.
Thank you, Representative. Committee members, any additional discussion on LD 2023? I am not seeing any discussion. Representative Babbage, your hand is still up.
I apologize.
Okay. I just wanted to make sure you didn't have anything else you wanted to share with us. I did want to let committee members know, and also those members of the public who are listening or watching, that committee members have until 48 hours after a vote is taken to register their votes. And I see that there is either a question or committee discussion. Representative Libby, go ahead.
Thank you, Madam Chair. Given the complicated happenings on this bill and the fact that one of our committee members did not have the chance to get her questions answered at the appropriate time, I move to table until that committee member can be present and have her questions answered.
Thank you, Representative Libby. Is there a second on that motion? Seconded by Representative Thorne. And I'm going to ask for a brief caucus with my Democratic colleagues. And so we will be in recess until 1:55. Thank you, everyone.
I'm looking for the damn thing, yeah.
Hey, Chris.
Yes.
Your mic's on.
Sorry.
Your mic's on.
Thank you.
Thank you. Thank you.
I'm looking for the link, Jeff. Sorry.
Thank you for the email. I'm clear now.
Committee members, if you're able to return to the meeting, please do so. Thank you, everyone. And Supi, when you're able to return to vote on the pending motion, could you please join us? Let me just look at the list. I think we've got everyone. Except for Representative Newell, if you are able to rejoin us for the vote, could you please do so? Thank you. All right, Supi, I think we're ready.
Thank you, Madam Chair. And just so I'm clear, this is the tabling motion. Is that correct?
Correct, on LD 2023.
Thank you so very much. Senator Carney.
No.
Senator Carney votes no. Senator Sanborn. Senator Kime. Representative Harnett.
No.
Representative Harnett votes no. Representative Babbage.
No.
Representative Babbage votes no. Representative Galgay-Reckett.
No.
Representative Galgay-Reckett votes no. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
No.
Representative Sheehan votes no. Representative Hagan. Representative Poirier.
Yes. Yes.
Thank you. Representative Poirier votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Thorne.
Sorry, I was looking up as to whether or not you could call a corner caucus after a tabling motion. I'm voting yay.
Representative Thorne votes yes. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell.
No.
Representative Newell votes no. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 3 members voting in the affirmative, 8 members voting in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much, Supi. And committee members, Representative Babbage, if I would appreciate if you would lower your hand for just one moment. Thank you. I would just like to address the committee regarding the tabling motion, which I appreciate where you're coming from, Representative Libby. And ordinarily, I would support the tabling motion. However, at this point in the legislative session, we have run out of days to do our committee work. We could not reschedule this for Friday. In addition, I was concerned that, first of all, I apologize for not appreciating that Robert's rules instead of Mason's rules apply in committee. And that was my mistake. But I also feel like, particularly on this bill 2023, we have had a huge volume of materials to help us understand the bill. We've had multiple work sessions. We've answered a lot of questions, and we've had the ability to do a lot of homework to understand the bill. And it's unfortunate that it came at the end of the session, but we need to vote our bills and send them on to the House and Senate floors where they can be debated and voted on by those chambers. And so it was because of the time crunch that I voted against the motion to table. And I considered, do we pass the motion to table and then reschedule the work session for later this afternoon. But I didn't really think that that would cure the problem here, which is that some members who still have questions left the meeting and haven't returned to the meeting. And so I don't know if there's any step that I could take that would cure that decision. And so for that reason, I ask that we continue our deliberations on 2023. We vote it. We give committee members who are not here the opportunity to cast their votes over the next 48 hours and proceed in getting our committee work done, because that is our obligation. And so thank you for hearing me out on that. And, again, I regret that there isn't more committee meeting time such that we could have moved forward with the tabling motion. Representative Libby.
Thank you, Madam Chair. I would simply point out that if we had followed proper procedure in the first place and allowed questions to be answered when they were had, we would not be in this pickle at this point. Everyone would have had their questions answered and we would have voted this out by now instead of revisiting it. So I hope we do so in the future.
I appreciate that. It seems to me that some committee members have been unavailable since before we took the vote on 2023. And so I'm not sure that, I'm not sure there's anything we could do to cure that. Representative Babbage.
Yes, thank you, Madam Chair. I just wanted to explain my own judgment. I appreciate the time constraint that we're all feeling, and that's real. But I came to my decision to bring it to a close today on this particular bill because unlike another bill where we're still looking for wording to be brought to us, right now we're determining whether or not we're going to oppose or approve wording that is before us. And for those that are absent, they do have until noontime Friday to get their questions answered. So I'm comfortable with that. So thank you, Madam Chair.
Thank you, Representative. Representative Thorne.
Thank you, Madam Chair. And if you'll indulge me, my reason for having the concern is reading about a motion to table. The motion to lay on the table is carried by majority vote and is not debatable or amendable. The Assembly may not debate nor take any action that would affect the tabled question until a subsequent in-order motion to take from the table is moved. So I'm just saying, as an assembly, you call for a corner caucus before the vote rather than take an immediate vote. And clearly by the rules, it says the assembly may not debate nor take any action that would affect the tabled question until a subsequent in-order motion to take from the table is moved. So that's my concern, is that after the motion to table, the corner caucus was taken and then came back, and I don't want to say the word all Democrats, but all those that weren't Republican voted no on it. So that's my concern, that it was unfair and not by the rules. So I've expressed that. That's all I'll say.
Yeah, and I guess I interpret what you read a little bit differently. And I know that it's the practice of this committee that in the past we have taken corner caucuses at the request of multiple committee members prior to votes on tabling motions. Representative Newell.
Thank you, Madam Chair. Just for the record, I am registered as an independent. And I just want to comment as to why I seconded the motion to move the question. Because I felt after 49 minutes of questioning by not more than one member of this committee, I felt I would second Representative Harnet's motion to move the question. And that's why I chose to second it.
Thank you, Representative Newell. Representative Harnett?
Thank you very much, Madam Chair. And briefly, I promise, I also read the section of the rules that Representative Thorne read very differently. We did not debate the motion. We did not take any committee action on the motion. We simply did what this committee has always done, and that's to allow members to caucus. We didn't caucus and debate the vote. You could only debate that on the in committee. So I think we are in compliance with the rules. And I know we disagree, but that's how I read it. Thank you, Madam Chair.
Thank you. Representative Thorne?
Thank you, Madam Chair. I promise this is the last time I'll rise to speak today. And to answer Representative Newell's, that's why I said all those that are not Republican. So I know we don't want to get into any partisan politics here in the committee. And also, that's why I raised a question. Co-Chair Harnett is just that the way it's interpreted. And if nothing else, it'll bring to light going forward for those of us that will hopefully continue in the legislative process going forward, that will be clear and established in the future for committee procedures. So thank you.
Thank you, Representative Thorne. Committee members, does anybody wish to be heard or wish to be heard on any debate or advocacy or discussion of the pending ought to pass as amended motion on LD 2023? I am not seeing any questions or debate, and so we will move on to the vote on LD 2023. This and Supi has appeared to take the roll. Thank you, Supi.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
No.
Representative Libby votes no. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 9 members voting in the affirmative, 2 members voting in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much, Supi. And for those who voted against the pending motion, could you please let us know what your report is?
Ought not to pass.
Okay, so 2 ought not to passes. And so the committee's vote is 9 ought to pass as amended, 2 ought not to pass, and 3 committee members who will have the opportunity to vote in the next 48 hours. And with that, we will close the work session on LD 2023. And I know that we still have 1945 to complete our work on, and we have a number of judicial nominations next week and the following week. Is there any announcements from either Peggy or Supi?
My favorite bill of every year hasn't been printed yet, the errors bill. And that, I don't know if that's on the calendar tomorrow or not, but it will be something we will be working on. And you might want to set up a subcommittee to do the detailed work, but that is still something that you will have to work through and vote on.
And Peggy, I think that you've piqued a lot of curiosity. Can you give committee members just a little nugget on what the errors bill is and also the format that it comes out in, because it involves picking up a binder?
Right. So the errors bill is it's by joint rule, and it's also provided for in statute. The revisor's office pulls together all the errors, inconsistencies, and conflicts. And if they are technical, meaning they don't change the effect of the law, but they just need to be corrected, they print it in the errors bill. And the errors bill gets referred to you. You usually have kind of a pro forma hearing. This year's bill is probably going to be about 60 sections. I've seen a preliminary look at it. I've had a preliminary look at it. So what we try to do, what my office does, is we go through each section and try to identify, make sure it really is a technical correction. We try to understand why it happened in the first place and whether this is the correct way to fix it. And what we've done in the past is have a subcommittee go through each section of that. I think we zipped through the errors bill last year really fast because it had been presented to the prior legislature and there were just a couple of sections that were added. So we didn't spend the time on it last year that we usually do for the errors bill. And then you can also consider any other amendments. You can add substantive things to it that are correct, that need correction, but that are actually substantive. They do change the effect of the law. And I know that the Criminal Justice Committee has already submitted a memo identifying a problem that occurred last year, and it needs to be clarified in the law. And I actually couldn't tell you if that's a technical or a substantive correction. But anyway, see, I'm getting all excited about diving into the details. But so it's something that the committee goes through. The rest of the legislature trusts you to make sure that you identify what changes are substantive and what are technical. So when it comes to the floor, people don't have to go through an 80-page bill and make sure nothing is getting, snuck through the process. So it usually takes, at least a couple days of subcommittee work to get through the whole thing.
Thank
That's
you.
something to look forward to.
Yeah, and it comes in binder format that we will have available to look at the actual physical paper, right?
Right. We hope to do that. Yes.
Thank you. That made it so much easier last year. Thank you.
Good.
Soupy, did you have any announcements for us? No? Okay, and I am actually remembering that we had another item on our agenda, which was discussion of any additional initiatives related to the Maine Commission for Indigent Legal Services. So kind of jumped over that item, and I apologize to everyone for doing that. Representative Thorne?
Thank you, Madam Chair. I hate to break my promise of not rising again, but while I had Peggy on, I didn't know, I wanted to confirm that Friday is a clear schedule for us.
That's my understanding.
Okay. And then secondly, when might that errors packet be ready for us? Thank you.
Definitely not before Monday. Maybe Tuesday.
Great, thank you. All right, committee members, and then let's take up our what I believe is our last item today, and that is to take another look at the initiatives that we had been considering for the Maine Commission on Indigent Legal Services. And I think the two that we were still outstanding was there a way to provide student loan relief and also to provide any help with healthcare coverage for attorneys who are have their own private practice or are in a firm, but take cases and are on the roster for the Maine Commission on Indigent Legal Services. And Representative Evangelos, I wanted to, if you don't mind me, calling on you and asking you how you're feeling about those other initiatives.
Well, given that we're running out of time, I don't want to be facing the commission or the legal profession with the fact that we didn't take a stab at this. I know Mr. Andrus, I believe it was Mr. Andrus, and then one of the other state officials sent us some, numbers. I don't know if you want to take some time to digest that and take it up when we take up 1945, or Mr. Andrus was here. These are both very complex issues, and I know that part of it is determinant on how much of a person's practice is private practice versus the semi-public practice of indigent legal, because we have to set up parameters. If we're going to provide health insurance relief, we have to ascertain that the person's going to be working for indigent legal most of the time. We also have some people that work for some pretty well-heeled firms that do indigent legal, and perhaps that firm's already providing health insurance. That's a long way of saying I don't have all the answers on this, but I do want the committee to make an attempt at addressing those two outstanding issues in the interest of parity. So I'll talk a little bit more about it, but I'd like to hear from either Mr. Andrus or the rest of the committee on what we can get done this year on those two items. Thanks.
Okay, thank you. Let's have start with committee members weighing in on what we think we can accomplish this year on those two items. And I would also like to throw in the mix my personal concern that I'm really concerned about even getting the initiatives that we've already proposed funded. And so I'm a little worried about creating, making a less focused presentation to the Appropriations Committee. And so I'll just throw that into the mix for committee discussion. Representative Evangelos?
One way I can address the health insurance issue is that when Mr. Andrus told us that the $100 an hour, the move to $100 an hour almost reached parity with his number configuration for somebody that works for the prosecution or the AG's office, he mentioned $105. Did that in comparison, Justin, did that include health insurance?
Let me bring him over to the panel to answer that question. And I do think your point is well taken, Representative, that is a way to address healthcare, student loans, and other needs that panel members have. Justin Andrus, welcome back. Did you hear Representative Evangelos's question?
Only in part. I came running back in when I realized you were discussing the commission, but I've missed some of the predicate.
Representative, can you restate that question about the 100 versus 105?
Sure. Thank you, Senator Carney. Good afternoon, Justin.
Good afternoon.
We've been, as you know, working on parity in a bunch of areas to level the playing field between the indigent legal defender and the prosecution side. And last week, or earlier this week, we're all tired and lost track of the days, but we talked about the $100 an hour came close to the $105 an hour that you had figured for the prosecution and attorney general's side, the attorney's salary and the benefits they receive and whatever support services they get. Did that analysis of the 100 for indigent legal versus the 105 for the prosecution attorneys, did that include health insurance?
It did. The answer is a little qualified. So the $105 an hour that I said, very near the $100 an hour, would provide the salary and the benefits, including health insurance, for an attorney and a staff person working full-time, but not the office overhead. That was the significance of that number. What I didn't say the other day, and meant to, was that assumes those benefits are being purchased with the purchasing power of the state. And so a retail health insurance policy is typically much more expensive than a group health insurance policy. And so it's hard to know where that shakes out for any given person because it's based on age and sex and all sorts of stuff. I suppose tobacco status, all sorts of things they ask about. So I don't have any way to know exactly how that shakes out for a specific attorney. Also, when we're talking about parity there, that ignores the pension contribution. And so there was no way to calculate for an equivalent thing. I know that's what we're not talking about, but I just want to be clear that's not included in that number I gave you earlier in the week.
Would you be able to do some research for us, even if it doesn't get implemented until a later date? And the Senate chair made a good point. I mean, we got a lot on the table already, but can we find out if Indigent Legal attempted to create, the availability of a group health insurance plan, sort of like the one we're on with the state, to take advantage of lower premiums if you group people together?
I'd be very happy to return to that project. I have failed so far. I usually can persevere and find a way. I've yet to find somebody who will walk through with me what it takes to administer that and what that really is. But I can go back to it. Sure.
Yeah, one of the things that should be explored to make it easy is whether or not, because you are a quasi-state agency, whether there was some way we could fold your agency into one of the existing state health plans, like the one legislators are on or something, so that, I don't want you to have to get into the administration business of a self-managed plan. That's a lot of work. But if there was an existing plan in the state, and, I know that when we go to a public defender, these things are going to start answering themselves because we're going to have to, there'll be public employees then. But I want to find out if there's an easy segue into health insurance using one of the existing state plans, given you're a state agency. And then we'd have a good handle on what the premiums would be for a single 2-person in a family. Then we could attach numbers to it. So I, this late in the session, these are 2 really complex ones also on the student loan, and I'm not on the other side of that coin on the second item, and I'm not besmirching any other professions, but I mean, if the state is helping veterinarians and we don't have enough lawyers to represent indigent clients and we're facing a massive civil rights lawsuit, we've got to, make things better in this area. Especially what I want you to explore is, it's kind of like people will make a commitment of time to your service, the Indigent Commission. Yes, I'm willing to serve as an indigent legal lawyer for 4 years, 5 years, and therefore I will receive the tuition relief that we're able to provide in the program. I don't want somebody getting the relief and then, saying, see you later. There's got to be, a catch that says, okay, you'll qualify for college tuition relief if you're willing to sign on for 3 years, something like that. I'm just throwing these out. We've got to develop some mechanics around it so it works. But I'm cognizant of the late hour, but I just don't want to face these attorneys we faced on December 9th and say we ran out of time. That's not good enough. What I would prefer to say at least is the $100 an hour came close to matching the benefits that a prosecutor gets with their wages. And we're going to work on a plan to implement a health plan and tuition relief for that profession that joins your service. Granted, we don't have much time now, but I just don't want to say we ran out of time. I want to say that we are working on it. And what we do beyond that, I'm not sure, given the calendar, but it's a tough situation. But after what I heard on December 9th, I'm not going to go back and face these people and say, well, sorry, on your tuition, on your health insurance, we ran out of time. It's got to be better than that.
Representative Evangelist, can I would love to just have a moment to respond, because I agree wholeheartedly with everything you said. My concern is that, like, when I think about my personal time, and I'm also concerned about this on behalf of Executive Director Andrus, like, we have this narrow window of time where we can really advocate before the Appropriations Committee for the initiatives that we've already provided them. And I kind of feel like we have to choose what we think is going to be most immediately impactful. And I'm concerned that if we're taking resources in the direction of coming up with new legislation that we don't even know we're going to have the committee time to vote on, then I'm worried that we're going to take our eye off the importance of what's currently before appropriations. And I'm just expressing that concern because, like you, I agree that it's really important to achieve parity, but I'm worried that we're going to miss the opportunity to get some really important stuff done if we go off on these and start to develop these other initiatives.
No, I hear you. I hear you, and I'm not disagreeing with you. It's a dilemma, isn't it? Because we realize, for the people that are in this working for the commission, as a lawyer, health insurance costs and tuition relief is a huge item individually to those, especially the younger ones, because it's gotten so much more expensive to attend law school. I don't want to muddy the waters with appropriations, but I wish we had gone to like at least $105, and then we could say we put enough money in there on the $105, and that should be enough to cover your health insurance. We didn't quite make it, but I know that there was some debate about a unanimous report. I want to be able to respond to these attorneys so that it's at least work in progress.
Let's let some other committee members weigh in on this as well. Representative Babbage. We're not able to hear you, Representative.
Thank you. Thank you, Madam Chair. I very much appreciate Representative Evangelos's work on this and his concerns. But I really feel we're still in transition with indigent legal services. I think I'm very excited. I think we've all done, wonderful work. But I think when we get to things such as loan repayment and health insurance, where we need to set up qualifications and thresholds, that at this transitory period, and I'm talking about, a 3 to 5 year period, I had hoped to address that. And I think it is best addressed through a higher hourly rate. And that's why I had kind of encouraged a $110 rate, 6.9 million, which would benefit people by the amount of commitment that they make to the program, without having to determine qualifications and thresholds and things of that sort. So I'm very sympathetic here, but I think the way to go is through the hourly rate in order to be just to all those who will serve the program. Thank you.
Thank you, Representative Babbage. Any other committee member wish to weigh in on this? Representative Harnett?
Thank you, Madam Chair. I think I join in everyone's concerns about, and I'll use the word plight, of the folks that are providing such an important and constitutionally required service, and that's representing indigent defendants. But I think many of the challenges that we're talking about, loan repayment, benefits, sick time, vacation time, scream out for the reason that we need a public defender's office, because it's through that those benefits can be provided. You know, as Representative Babbage mentions, we are in a transition period, but then again, we're not. We still don't have a public defender's office. We've asked for a geographically limited project. We've asked for a rural mobile unit, but we don't have those yet. And I'm hopeful, but I don't know if we are going to get them. And I just say that because the easiest way to address these problems are to make these persons employees of the state, where they are treated like the prosecution is treated, not just in salary and benefits, but in ancillary services, in support staff. So I can see in the short run Representative Babbage's point that increasing the dollar amount might give, no pun intended, the most bang for the buck. I think we still have to keep our eyes on what is the proper structure to provide these services to our indigent defendants. So, thank you.
Any committee members, any other thoughts? Representative Babbage?
Yes, only that I appreciate the representative's comments, and when I meant transition, I meant that I do think a public defender's office, you know, and perhaps a hybrid, but there would be an expanded staff in a public defender's office in the future, which would be the proper way to ensure benefits. But you know, I'm reminding folks that in federal court, an assigned attorney is at $150 an hour. So that's where I was coming from. Thank you very much.
Thank you, Representative. Representative Moriarty?
Thank you, Madam Chair. Very briefly, 2 days ago, we approved 6 initiatives, which I think, should they be approved, help to accomplish our mission. I don't think at this point that we have the time or the resources to develop a student loan relief program from scratch, or to develop a program for extending healthcare coverage to non-state employees. It's just beyond our ability to accomplish.
Thank you, Representative. We've got 2 hands up still, and I just would ask Representative Evangelos, go ahead, and then I think we need to come to a conclusion on this discussion. Go ahead, Representative.
I agree, Madam Chair. Does anybody know how much the Appropriations Committee, how much money they have to deal with? How much is on the table to fill all of the requests? Does anybody have that number?
No.
And how do we get the number? Does anybody know? Peggy, do you know how we get that?
I don't know if that number, I mean, I hear rumors about it. I'm never part of that process, but I don't know if that's established, because I don't know that the governor's change package has been submitted. It's usually after that happens that they figure out how much they have left on the table.
Yeah, I saw one article in the paper. I saw $20 million, but I don't know if that was just the change package or not. It was an article about increasing these checks to $875, and the article said there was 20 million left for the appropriations table. My concern is the PFAS bill alone is 100 million. You know, we're running the risk here of getting nothing. I hope we all understand that. If appropriations doesn't approve our line requests, we didn't accomplish anything we wanted to. The public defender experiment goes down the drain. It's not going to be $100. This is it's a dilemma. I know I don't. It's that dilemma is not going to get improved by putting anything more on. I hear you, Representative Moriarty, but we're taking the chance that 13 members of that body they're going to pick the items. They'll prioritize what they want to finance. We can go in there and make the best case we can, but there's a risk that we're not going to come back with anything, and that would be terrible.
Yeah, I appreciate that, Representative. And I guess back to my original point, I'm not sure adding more items to that list is going to help us get that list funded.
Well, I heard Representative Harnetti's right. The problem solves itself if we move in a new direction, a bigger direction. But in order to sell that to the state, we got to get the pilot program going and show it's successful. So will we be meeting with appropriations again to sell our issues, or?
We have requested an opportunity to address them specifically on the indigent legal services, civil legal services issues. I don't know that we have it. I don't think we have a date from them yet.
Well, then that'll help. And then we can ask them how much they got on the table to deal with. So thank you for the discussion. I know in a better system and better times, we'd be able to fix more of these things, but I want it heard loud and clear to the professionals who work for the system. And I think most of the committee members feel this way, that we're not done. We heard your concerns on December 9th, and we're trying very hard to address them. Thank you.
Thank you. And then, okay, so is everybody all set for now with the indigent legal services discussion? So we've got just a couple more wrap-up things on our agenda. We have some committee members who wish to vote on camera on some votes that they were not able to make earlier this week. And I am not exactly sure which bills those are. Peggy, did you have some more information about that for us?
Right. It was just the MCILS and civil legal services initiatives that you voted on Tuesday. I did send out the voting sheets and the initiatives to the people who weren't there. And I have heard back from Senator Sanborn sent me her vote on the initiatives. But I know that Representative Poirier, Representative Libby, Representative Newell, and Representative Hagan missed, I think, all of them. And I believe Senator Kime missed one of them. Nope. I've got her on everything. So I don't know. And maybe this is just coming up too fast, and maybe they want to think about it and email me their votes as I put it together to send to appropriations.
Yeah, it looks like Representative Libby is here, and Representative Poirier and Representative Newell. So maybe they could move forward with that. Representative Libby?
Thank you, Madam Chair. I actually am going to have to vote via absentee or email or whatnot. I am having to leave committee for the afternoon literally in about 30 seconds. So I just wanted to pop on here and say that, so it's not too abrupt that I'm leaving.
And one quick question, these were votes on Monday, and so is today the last day to vote on them?
It would be good to have them today, yes. And if you have questions, if you would email me or call me, that would be great.
It's an email?
Yeah, I did send it in an email yesterday or last evening.
Okay,
yes.
Perfect. Thank you.
Okay. Yep, thank you.
Thanks. And then Representative Newell, did you wish to cast your votes?
Thank you, Madam Chair. I too will look at my email, Peggy.
You know what? I will just send it again to the people who missed, so it'll be right on top.
I know I was pinning stuff this morning. Thank you.
All right.
Thanks. And then Representative Poirier, are you able to join the meeting? I know she said she had to be pulled away for something, so maybe that's not going to work for today. Okay, I think have we covered everything, Peggy?
I think so. If you're done with those, right, if you're done talking about MCILS, that was on our schedule. And I'm not sure when you're going to take up 1945 again. Right,
and perhaps when we do the errors bill, we'll see. But we will get to work on that. Okay, committee members, does anyone have a motion to adjourn?
So move.
Lauren, and then lots of seconds. All right, we'll see you all tomorrow. Subi, did you have anything for us? No? Okay, great. All right. Thanks, everyone. Good night.
Okay, thanks then.
I thank you.